Hey, what's up, guys? Welcome to Law-Splaining the Interwebs. I am your host, Nick Rekieta of Rekieta Law. Losing my voice, a small law firm in central Minnesota. And hey, guys, how are you? Hope you're doing well. Don't worry about my voice. It's just the voice. I'm not sick. I wish I would. No, I'm just kidding. Oh man, this is not a pleasant feeling, but we shall soldier on because the law gods have gifted us with comedy abound. And we are gonna say, yeah, my hair, I just put water in it. It's not gel. It was all over the place. I was asleep on a couch. I have ruined my sleep schedule so badly that it's now normal. So, it's, I don't know what to do. I went to bed yesterday. I didn't do a show and I ended up going to bed at 10 and I woke up at 5:30 in the morning. And I was like, wow, this is stupid. So I went back to sleep because I don't want to be awake that early. And then I got up at 8 today. So I feel like now my sleep schedule is treading back into normie territory. So I'm going to have to ruin it again. So who knows? Who knows how that goes? What the plan will be. I don't know. Maybe like another 24 hour. I'm just kidding. That was a joke. Oh boy. So we have something to cover today. We have, of course, this George Zimmerman lawsuit, which I have not read the suit. I've read the synopsis of the suit. We're gonna read through it. Who knows? I don't know what's in there. I know a little bit about what's in there, but it's a good chunk. It's like 30 something pages. So we'll go through and read all of the allegations. Do you guys know? I hope you remember who George Zimmerman is. Hold on. I had the open it in Acrobat. What's wrong with you? Anyway, George Zimmerman, if you don't remember, because it was a long time ago, back in 2012, I think it was, he decided to be a hero and neighborhood watch this kid, Trayvon Martin, and followed him around, thought he looked real suspicious. And then he ended up, in some way or another, just accidentally happenstance his way into some sort of fight with Trayvon, who was 17. Zimmerman's a man. Trayvon was like 17 or whatever, and managed to get himself into a little bit of a scuffle. And there are different stories as to how. Some say that Zimmerman followed Trayvon. Trayvon turned around and attacked him. Some say Zimmerman was following Trayvon, lost track of him, went back to his truck, and Trayvon was waiting for him. I think that was Zimmerman's story. There's not a witness. So we don't really know what happened other than whatever Zimmerman says happened. He may be a little biased, trying to not go to prison for shooting someone. But either way, what ends up happening, what we do know is that Trayvon ended up somehow on top of Zimmerman and was mercilessly pummeling his face in all of the ways that you would want to pummel a face. And if you've seen Zimmerman's face in the police car after the shooting, I mean, he was kind of a wreck. And apparently he was getting his head smashed into the concrete, right? During that, he pulled his gun, he fired, and he shoots Trayvon Martin. And he ends up winning the lawsuit for a justifiable use of deadly force. Or not really winning the lawsuit. He ends up avoiding being prosecuted. Now, he was initially let go by the sheriff. They refused to arrest him at first. They took him to the hospital, looked at his injuries, and said, well, self-defense. Then a couple weeks later, there's a bunch of pressure, and they prosecuted him, and he ended up winning later than that, after that. And then there was a federal investigation into him to see if, how do I word this? To see if they really did want to prosecute him. See if he violated a federal hate crime law or something. And they did 3 years. Only the 3 years of investigation into him. And decided that the publicity was no longer there. And there was no reason for them to keep pretending that they were going to do something that they didn't actually have an intention of doing. And they ended up dropping anything against him. No charges were ever filed after that federal investigation. Only the 3 years, though. What we've learned about Zimmerman from 2012 to now is a repeated, how do I put this? A repeated display that the guy seems to be a jackass in general. But, you know, that's not actually illegal. It's not actually unlawful to be a dirtbag. You could be a dirtbag. That doesn't mean much of anything. So he's he does seem to be a complete dirtbag, but that's where we are. But if you didn't get the fact that he was a neighborhood watch person following people around and calling the police, I mean, George Zimmerman is a Karen. He's a Karen of the neighborhood. Those kinds of people are just typically dirtbags in general. So anyway, but now he has sued Trayvon Martin's parents. He has sued the prosecutors. He has sued the Benjamin Crump. I thought he was a prosecutor, and he sued Rachel John Teal. He sued a bunch of people for $100 million, and we're going to talk about that tonight. So it seems like a really interesting case. Actually, when you start getting into it, if any of this is true, it's wildly amazing and spectacular and very interesting. Should make a good lawsuit. Or it could just be completely fake. We'll find out at some point. Mike Walters says, so from what you told us, as Vic's appeal moves forward, you said that the appeals court would review everything in the record. Does that mean everything submitted is reviewed as if the TCPA hearing never happened? Not quite. Not quite, but kind of. So the record in the appeals case is actually created by what's in the clerk's record, combined with what Vic's team requests to be included in the record. All right. So they have to send the record to the appeal, or they have to notice the appeals court on what they consider to be the record. They have to pay for all of that. You pay like by the document. It gets very expensive depending on how much is in there. I wonder if Lemoyne knew that when he filed his like 1,000-page, or 600, 700-page thing. Anyway, so you got to pay for all of the for all of the stuff that you include in the record. And there's actually a filing, since the new ruling has just come out very recently about the status of the fees and the sanctions that we talked about, Vic's team has filed a supplement to their clarification of the record. And it's to add all the new stuff that they filed for the fees into their original request for the record. We'll probably go through that at some point. But, you know, that's there. That's been filed. And that's where we are. As for the rest of Vic's stuff, I am waiting for the transcript to be available. As soon as the transcript is available of that hearing, we will be going through it. I thought it might come out today, but it did not. So maybe it'll be up tomorrow. Not sure. Is the Slaytosh statement in the record? It is. But here's how that works. Like, just because it's in the record doesn't mean the appeals court is going to give it weight or consider it. What they'll have to do, you know, all of the stuff that's in the record is in the record, including the opposition to Slaytosh's affidavit and unsworn declaration. So the whole drama around that affidavit and unsworn declaration will be in play at the appeals court. They'll have to determine if Judge Chupp could properly exclude the unsworn declarations, like he ended up doing. Now, how that kind of played out in court was that they mentioned that the affidavits were withdrawn, and then Judge Chupp said he wasn't considering the second amended complaint, right? And so Ty made what's called a trial amendment. He asked for a trial amendment to add the unsworn declarations as a cure for the affidavits that were withdrawn. And Chupp said on the record that he had read the affidavits and he was probably going to consider the affidavits, and he didn't actually rule on Ty's trial amendment. So then later in his decision, you know, he mentioned that he wasn't going to consider, that he didn't consider the affidavits or the unsworn declarations. And so that whole issue that'll be part of the appeal, right? Look, we tried to introduce these things in a second amended complaint. The court indicated that it wasn't going to consider the second amended complaint, which they'll also argue wasn't actually something the court could do because it didn't strike the complaint. It just said it wasn't going to consider it. And so they'll be arguing that that was improper and that the appeals court should reverse that decision and include the second amended complaint. But even so, they'll say, because they didn't allow this, we tried to make a trial amendment, and then the court refused to rule on the trial amendment and didn't offer us a chance to provide argument as to why that trial amendment should be allowed and all of that stuff. And the proper remedy for the defective complaint should have been to allow the complaint or defective notary should have been to allow for correction through the unsworn declarations. Also, they'll be making all those arguments to the appeals court, and they'll suggest that everything that was done at the district court level was incorrect. So will the appeals court see them? Yes. Will they consider them? Maybe. You know, we'll see. But anyway, we'll see. Yeah, so we'll see. Mithrin Emrys says, I get they are separate systems, but that whole win in state and we will sue you in federal court thing just carries a whiff of going against the spirit, if not the letter, of double jeopardy. CFPS Russia. Yes. Yeah, it's a nasty thing, and it's especially nasty when it's motivated by the mob, right? George Zimmerman was a target of the federal government because of the mob. The mob demanded blood for blood. George Zimmerman shot Trayvon Martin. The state said they couldn't do anything. So the federal government, apparently at the direction of Obama, decided that they would try to do something because they had to placate the mob. And that's not how justice should occur. That's actually why we have a criminal justice system that we have is to avoid the mob's ability to influence that system. Same thing happened with Darren Wilson and Mike Brown, and the feds came in and reviewed Ferguson Police Department and the shooting of Mike Brown very thoroughly for a very long time to see if, even though the state court decided that Darren Wilson was not guilty, or well, that they wouldn't prosecute him, the feds came in and tried to find out if they should prosecute him. And what their investigation turned up was, no, they shouldn't prosecute Darren Wilson, but oh yeah, the Ferguson Police Department has a strong history of racism and being terrible. The first part I'm not so sure about. The second part seems to definitely be true, because most police forces, I mean, you can find terribleness in them. They're run by people, so they're gonna have their issues, right? But anyway, yeah, I'm not a big fan of dictating who the federal government will investigate by mob rule. Oh yeah, another story we'll be covering soon, I guess, is maybe I can find it real quick. I found some irony on CNN. Hold on. And unfortunately, it's like a video. Oh God. Yeah, it's a video. So I'm not going to watch it here. But I just want you to see the headline, because that's all we really need for you to get the idea of the irony of CNN. Okay, here we go. Let me open this. Here we go. Let's get this more in frame. Look at that. The founding fathers wanted to safeguard against tyranny. So you're like, oh, cool. CNN's finally doing a proper video on the Second Amendment, right? Because that would be a very great video name for an expose on the Second Amendment and what the founding fathers intended with the idea that everybody would have guns. But does it have anything to do with the Second Amendment? No, of course not. This is about CNN's Jamie Gangle walks us through the history of the impeachment clause and highlights the fear the founding fathers had toward tyrannical rule. It's about impeachment. So there you go. That's what it's about. That was the safeguard against tyranny was the impeachment. And the safeguard against tyranny was so dire to the founding fathers that they pared back basically everything that was impeachable to be this general statement about high crimes and misdemeanors and bribery and treason or whatever. So, they could have left a whole lot of other things in there, but no, they didn't. That's how terrified they were. Very, very terrified. Now, they were terrified against tyranny. They were not just terrified of tyranny from the king, though. They were also terrified of tyranny from the legislature. They're terrified of tyranny from the courts. They're terrified of tyranny from government, a government which they made terrifically small. And then we have blown far out of proportion. But I just thought that was great. Good job, guys. You'll talk about how they want to safeguard against tyranny through the impeachment clause, but not through the Second Amendment, which is a direct call to safeguard against tyranny. Oh, here's this. Here's Larry. Mr. Schwagen says, what's worse, Zimmerman being a narc Karen or NBC editing audio to make him sound super racist? The media trying to make this a black-white issue even though he was Spanish is sad. Yeah, that whole thing was an absolute mess. Was that NBC? I couldn't remember if it was NBC, ABC, CBS, CNN. I didn't remember what letter soup it came from. But anyway, Yeah. So this is Larry Klayman. I guess we can go ahead and jump into this topic. We'll jump into this topic. George Zimmerman. So this is Larry Klayman, attorney at law. Here's this guy. You may know Larry Klayman if you've ever heard of Judicial Watch. He is the founder of Judicial Watch. But he's split from Judicial Watch since founding it. So he's not still there. But Larry Klayman is a known right-wing attorney. So the media already hates him. I got to get this guy on the show to have him talk about this. But yeah, so he is representing George Zimmerman. This is the press release page for Larry Klayman, okay? So we'll take a look at this. Tomorrow there's a press conference at 12 p.m. followed by at 1 p.m. the Trayvon hoax film. So Boca Raton, Florida, December 4th. Larry Klayman, founder of Judicial Watch and Freedom Watch, and a former U.S. Department of Justice prosecutor, is representing George Zimmerman in a lawsuit alleging that the prosecution's key witness in his 2013 murder trial, Rachel John Teal, was an imposter and fake witness. This is like LA Law and Order, NYPD Blue. Like, this is perfect. The suit, styled Zimmerman versus Crump et al., filed in a Florida state court, also alleges defamation by the Martin family attorney Benjamin Crump. Specifically, the complaint alleges that in March 2012, the Sanford Police Department thoroughly investigated the shooting of Trayvon Martin and closed the case as self-defense. A week later, Martin family attorney Benjamin Crump produced a recorded audio tape of Diamond Eugene, whom he said was Trayvon's 16-year-old girlfriend, who was on the phone with Trayvon just before the altercation. However, 2 weeks later, 18-year-old Rachel John Teal, the alleged imposter, appeared before prosecutors claiming to be Diamond Eugene and provided false statements to incriminate Zimmerman based on coaching from others. These allegations are the result of newly discovered evidence just published in a book and filmed by Hollywood film director Joel Gilbert called The Trayvon Hoax: Unmasking the Witness Fraud That Divided America. Based on Trayvon's cell phone records, they allegedly show that Rachel John Teal was not Trayvon's girlfriend, was not on the phone with Trayvon before the altercation, and that she lied repeatedly to cause Zimmerman's arrest and to try to send him to prison for life. The research also allegedly reveals that Trayvon's real girlfriend and legitimate phone witness was in fact Miami resident Brittany Diamond Eugene, who was switched out for John Teal when Eugene refused to bear false witness against Zimmerman. The defendants include those who allegedly either have been proven to know about the switch to the imposter witness, such as Trayvon's mother and 2020 Miami-Dade Commission candidate Sabrina Fulton, and others such as Tracy Martin, attorney Benjamin Crump, Florida prosecutors Bernie Della Rionda, John Guy, Angela Corey, the state of Florida, and FDLE, all of whom are alleged to either have known or should have known about the witness fraud, obstructed justice, or lied repeatedly under oath in order to cover up their knowledge of the witness fraud. Zimmerman, who faced a life sentence had he been wrongly convicted based on the alleged false evidence, is suing for damages in excess of $100 million. So that is the press release. We do have the documents provided here by Larry Klayman. There's also, good. There's also there's a letter to, Harper Collins and Benjamin Crump. Oh no. We'll have to take a look at this. So here's the thing with Zimmerman, right? He's suing for $100 million, which is quite a bit. quite a bit of money. And whatever you think of George Zimmerman, like I said, I think he seems like a dirtbag. But he is George Zimmerman, which means that he is so thoroughly labeled a racist murderer forever that what's he gonna do, right? What's he supposed to do? Where's he gonna get a job? How does one go on from this anymore? This is a problem. This is a serious problem with how we conduct these public accusations against people now. We have a system that creates villains out of people who are legitimate system finds innocent, and then the villain status remains forever. So $100 million, is it unreasonable? Maybe. I don't know. His life's over. He can't. What would you do? What do you do? It's the same thing with Sandman, right? Like the media took this kid and painted him as a horrific racist, destroyed his ability to get into a lot of schools, destroyed his potential for work. I mean, this type of stuff can stick with someone for a year, or it could stick with someone for a lifetime. Zimmerman shot Trayvon Martin in 2012, and in 2019, they're still talking about him. It was the flashpoint. It was the flashpoint for a lot of things. It was the kickoff, so to speak, of a bunch of highly publicized law enforcement violence against Black people, which is interesting because Zimmerman was not law enforcement at all. They tried to kind of draw that parallel with the neighborhood watch thing, but it didn't end up sticking. But the whole thing here is the question of what do you do after this accusation? And Zimmerman is a name we know. Darren Wilson, I don't know if it... the guy, that's the guy who shot Mike Brown. I don't know if even he has the name recognition that Zimmerman does. But who killed Eric Garner, right? Like, I don't even remember that guy's name. Or the cop who killed Alton Sterling, I think it is the guy's name down in New Orleans. I don't remember the name of the guy who shot Philando Castile. Zimmerman, though. Man, they've got his name. His name is, you almost know it. It's known almost as well as Trayvon Martin. So that's why you sue for $100 million. I just wanted to point that out. It's kind of a weird thing. So, dear Mr. Crump and HarperCollins, I represent George Zimmerman. In your new book, just released on October 15th, 2019, titled Open Season, Legalize Genocide of Colored People. And that's what it says, YouTube. Don't blame me. And published by HarperCollins. I note with alarm that you are continuing to try to build a career as a race hustler by defaming my client. Ironically, it is you who are once again declaring open season on George Zimmerman, this time to try to sell books by again damaging my client's reputation with untrue and defamatory statements, depicting him as attempting to commit genocide. This amounts to defamation per se, for which damages under Florida law are presumed. You are also trying to use my client to divide our country, using George for your own personal promotion. You will recall that on March 12, 2012, Sanford, Florida Police Chief Bill Lee, not to be confused with Florida Police Chief Billy, announced the results of the Sanford police investigation into the Trayvon Martin shooting at a press conference. As you well know, Lee explained that the police investigation had included extensive interviews with eyewitnesses, including Jonathan Good, numerous retreat at Twin numerous retreat at Twin Lakes residence, reviews of 911 calls, examinations of the physical evidence, including Zimmerman's broken nose and head lacerations and Trayvon's bruised knuckles, and the location of the altercation. You're also aware that your own client, Tracy Martin, had told police that the voice on the 9/11 tape screaming for help was not his son. Police Chief Lee declared the shooting was found to be self-defense and there were no grounds to arrest Zimmerman. It was not even a stand your ground case, which is true. And this is something to remember. Stand your ground gets bandied about in all of these Florida shootings, including in Zimmerman's case. Even today, I believe it was on CNN that I was reading about this, and they called it a stand your ground case. Was it CNN or was it NPR? Hold on. Oh, here we go. Yeah. It's right here at the beginning of this NPR piece. Let me zoom this in a bit. George Zimmerman is suing the family of the teenager he shot nearly 8 years ago, seeking more than $100 million. Blah, blah, blah. No evidence to back Zimmerman's contentions that he was the victim of a conspiracy. He's acquitted on all charges related to shooting Martin, who was 17 and unarmed when Zimmerman shot and killed him in a gated Florida community. He had 2 arms, you liars, where Martin's father lived. Zimmerman claimed he shot Martin in self-defense during a scuffle. Zimmerman had faced charges of second-degree murder and manslaughter in the case, which also shed light on Florida's stand your ground law. Weird. Because it didn't have anything to do. They've got it tagged as stand your ground. Right there in their little meta tags. Why is that? Because it's always going to be about stand your ground. I'm told, by the way, that there's a poll on this video. Somewhere, there's like a little eye. Maybe up in the corner. Which corner? This corner? Maybe in the other corner. I don't know. That there's a poll that you can participate in. Go ahead and check that out. So it's always about stand your ground, though. And stand your ground is very weird, especially for Zimmerman, who had no duty to retreat at all. So and not because of stand your ground. Zimmerman shooting Martin in any state in the U.S. would likely have been resolved the same way. Stand your ground law didn't apply, shouldn't apply. When you're on your back, on the ground, and someone is on top of you, hitting you and pounding your head into the ground, you can't run away. You can't retreat. So there wouldn't be a duty to retreat affirmatively in any state, right? Like they could determine whether or not the shooting was justified on any other grounds, but there would never be a question of the duty to retreat because you can't retreat when you're literally laying on your back. It doesn't work that way. This is just a clear misstatement of stand your ground. It always is, and it's always going to go back to it. Michael Drezhka was called a stand your ground case. It was not, and that was by, to be fair, the sheriff of Nottingham, who refused to arrest him and then went to the media crying about stand your ground laws preventing him from arresting Drezhka, which isn't how it works. It's always going to be about stand your ground. Okay, here we go. Back to it. It was not even a stand your ground case. Despite this, you not only violated a myriad of ethics rules that govern the behavior of a Florida attorney, but also the law when you began an illegal campaign to defame Zimmerman, incite the public against him, and influence his girlfriend, Brittany DeMond Eugene, whom you knew had been on the phone with Trayvon up to the minute of his death. You began your campaign by disseminating into the media a knowingly false narrative that Trayvon was just buying candy for his little brother and was just trying to get home when he was stalked and attacked by Zimmerman because of his skin color. To further your false narrative, you disseminated a photo to the media of Trayvon when he was only about 10 years old and 5 feet tall, rather than providing recent photos of the 17-year-old who stood over 6 feet tall. You repeated your false narrative in the media often and daily, and in doing so, successfully defrauded and coerced the media, the president, celebrities, and fair-minded people into demanding the arrest of my client with no evidence. Also, I'm sure you recall that you recruited others to personally join your defamation and incitement campaign against Zimmerman, such as the Reverend Al Sharpton. At a Florida rally with Sharpton in tow, you shouted to the crowd, "We called up to New York City and got someone with a track record." You want Al Sharpton's track record? Referring to Sharpton, whom you knew was instrumental in spreading the Tawana Brawley race hoax in 1987, had incited violence that led to the Crown Heights riots in 1991, and who had incited anti-Semitic hatred that fueled the Freddy's Fashion Mart massacre in 1995. With Sharpton's help, your defamation and incitement efforts escalated into massive public protests demanding Zimmerman's arrest, death threats against Zimmerman, and was so effective that it even outraged celebrities like Roseanne Barr and Spike Lee, such that they tweeted the home address of Zimmerman's parents and invited mob action against Zimmerman's family, who were forced into hiding. And by the way, Spike Lee and Roseanne Barr still on Twitter. Mr. Crump, at this time you will be held accountable for your defamatory language in your book titled Open Season, Legalized Genocide of Colored People. On behalf of my client, I therefore demand that you and your publisher, HarperCollins, retract the defamatory language by noon, December 4th, 2019. That was today. Ultimatum given. Number 1, cease and desist sales of your race hoax book, Open Season, Legalized Genocide of Colored People, in all forms, hardcover, ebook, audiobook, and MP3 CD till new versions are produced. That does not contain the defamatory material below. Recall all books currently on any bookstore shelves or in any warehouse of distributors like Amazon provide an accounting of all sales in all forms to date. That's for damages. Publicly retract the false and defamatory statements in your book, which are defamatory. These include, but are not limited to, quote, testimony at the trial revealed that law enforcement ordered Zimmerman not to pursue the teen and to stand down until police arrived. Zimmerman continued to pursue Trayvon. Facts. 1, law enforcement ordered Zimmerman not to pursue the teen. It's not true. It's not what happened. This is false. Law enforcement did not order anything. The non-emergency dispatcher Zimmerman was speaking with was not law enforcement. Your statement falsely implies Zimmerman disregarded instructions of a police officer, implying that Zimmerman did something wrong that led to the death of Trayvon Martin. Now, to be fair, I think Zimmerman did a lot of things wrong that led to the death of Trayvon Martin. It's always sad when someone dies from one of these things. That doesn't mean he did it criminally. I skipped a paragraph? No, I didn't. That was weird. Anyway, let's see. So, B. Zimmerman was not ordered not to pursue the teen. After the non-emergency dispatcher repeatedly requested help from Zimmerman in determining where the individual who had circled his car is gone, Zimmerman left his car only to assist the dispatcher. As you know, when the dispatcher asked George if he was following him, Zimmerman said, yeah. Dispatcher stated in response, we don't need you to do that. And Zimmerman said, okay. He then asked the dispatcher to have an officer meet him near back his vehicle. Okay. As Zimmerman was approaching his vehicle was when he was attacked by Trayvon Martin, as all the evidence proved in court, where Zimmerman was acquitted in 2013. Now, this is obviously written favorably towards Zimmerman. The criticism one could levy against this, and this is the narrative, and it's the best narrative we have, but the criticism would be that we don't know that this is actually how it took place because we only have Zimmerman's word for it. But it's the words we've got. So that is the criticism of this story. But we don't actually have anyone to testify otherwise. Ordered Zimmerman to stand down until police arrive. False! False! No police officer nor any dispatcher ordered Zimmerman to stand down until police arrived. The statement defames my client, leads the public to believe he acted against instructions of law enforcement. And guys, I know people who are red-pilled people who still don't accept this narrative. And believe that Zimmerman somehow did something against police orders or whatever. Zimmerman continued to pursue Trayvon. This is totally false. The 9/11 recording and all testimony and evidence at trial proves this statement to be false. And yet another attempt to defame and incriminate my client for a charge that he was acquitted of. All evidence presented at trial indicated that Zimmerman told the non-emergency dispatcher he was walking back to his car to meet the officer and was approached and attacked by Trayvon Martin. The location of the incident was near Zimmerman's car. On behalf of my client, George Zimmerman, we expect an affirmative response by noon Wednesday, December 4th, to all of our demands. Otherwise, we will be compelled to file suit. Govern yourself accordingly, Larry Klayman. Okay, that gets it for me. That one wins. That one is my favorite. It's not sincerely. It's not very truly yours. It's nothing. It's great. Govern yourself accordingly. That is a fantastic sign off to the letter. That's a good way to do it. I might try and steal that from him, except I don't write letters. Woo! Okay, so that is from the Klayman Law Group. Larry Klayman. Oh boy. So we've got now we've got the complaint. In the Circuit Court of the 10th Judicial Circuit, in and for Polk County, Florida. We're in Polk County. Look at all these people. We've got George Zimmerman as plaintiff, Sabrina Fulton, Benjamin Crump, Rachel John Teal, Brittany Diamond Eugene. So he's suing the real girlfriend and the fake girlfriend. Tracy Martin, Bernie De La Rionda, John Guy, Angela Corey, Florida Department of Law Enforcement, the state of Florida, HarperCollins Publishers as defendants. That's a lot of motions that are coming. Does Florida have an anti-SLAPP? I don't think it does. Oh wait, no, I think Florida might. It does have an anti-SLAPP law. Okay. So this is let's take it's short-ish. Take a quick gander at Florida's anti-SLAPP law, because this is coming. This is coming. Just like me. Strategic lawsuits against public participation prohibited. So they get an extra P. Should be a slappy law. It is the intent of the legislature to protect the right in Florida to exercise the rights of free speech in connection with public issues and the rights to peacefully assemble, instruct representatives, and petition for redress of grievances before the various governmental entities of this state as protected by the First Amendment to the U.S. Constitution and Section 5, Article 1 of the state constitution. It is the public policy of this state that a person or governmental entity not engage in SLAPP suits because such actions are inconsistent with the right of persons to exercise such constitutional rights of free speech in connection with public issues. Therefore, the legislature finds and declares prohibiting such lawsuits as herein described will preserve this fundamental state policy, preserve the constitutional rights of persons in Florida, ensure the continuation of representative government in this state. It's the intent of the legislature that such lawsuits be expeditiously disposed of by the courts. As used in this section. This is it. This is the whole law. You'll notice it's a lot shorter than Texas law. I'm not sure. Let's see if it's how strong it is. Strong it's worded anyway. As used in this section, the phrase or term free speech in connection with public issues means any written or oral statement that is protected under applicable law and is made before a governmental entity in connection with an issue under consideration or review by a governmental entity, or is made in or in connection with a play, movie, television program, radio broadcast, audiovisual work, book, magazine article, musical work, news report, or other similar work. Governmental entity or government entity means the state, including the executive, legislative, and the judicial branches of government, and the independent establishments of the state, counties, municipalities, corporations, primarily acting as instrumentalities of the state, counties, or municipalities, districts, authorities, boards, commissions, or any agencies thereof. 3. A person or governmental entity in this state may not file or cause to be filed through its employees or agents any lawsuit, cause of action, claim, cross-claim, or counterclaim against another person or entity without merit, and primarily because such person or entity has exercised the constitutional right of free speech in connection with a public issue, or right to peacefully assemble, to instruct representatives of government, or to petition for redress of grievances before the various governmental entities of the state as protected by the First Amendment to the United States Constitution. Just a second. Mithrin Emrys says, involvement in a lawsuit does not make one a public figure. Time Incorporated versus Firestone. Accusation of criminal conduct does not make one a public figure. Wollston versus Reader's Digest. Very interesting questions on who will be a public figure in this. Zimmerman undoubtedly would be he almost has to be considered a public figure. I think he's done interviews, and that might be enough. But we'll see. We'll see the arguments. Random Blaze says, Dunford and Low T are going hard against North Carolina Division Sons of Confederate Veterans and the UNC system. Shane created a GoFundMe to buy you a good pair of court shoes. It had a $10 donation already. I know, but that donation is from Shane is a rapist. So I'm not super concerned about it. But Miss a Rapist, I mean, thank you for your thing. They realized, right, that I wasn't the actual attorney, so that I was wearing, I think I even announced ahead of time that I would wear tennis shoes in my suit. It's just a shame. It's just a shame. It's a shame what triggers them. Number 4, a person or entity sued by a governmental entity or another person in violation of this section has a right to an expeditious resolution of a claim that the suit is in violation of this section. A person or entity may move the court for an order dismissing the action or granting final judgment in favor of the person or entity. Person or entity may file a motion for summary judgment together with supplemental affidavits seeking a determination that the claimant's or governmental entity's lawsuit has been brought in violation of this section. Claimant or governmental entity shall thereafter file a response in any supplemental affidavits. As soon as practicable, the court shall set a hearing on the motion, which shall be held at the earliest possible time after the filing of the claimant's or governmental entity's response. Court may award, subject to the limitations in section 768.28, party sued by a governmental entity actual damages arising from a governmental entity's violation of this section. Court shall award the prevailing party reasonable attorney's fees and costs incurred in connection with a claim that an action was filed in violation of this subsection of this section. In any case filed by a governmental entity which is found by a court to be in violation of this section, the governmental entity shall report such finding and provide a copy of the court's order to the Attorney General no later than 30 days after such order is final. The Attorney General shall report any violation of this section by a governmental entity to the Cabinet, the President of the Senate, and the Speaker of the House of Representatives. A copy of such report shall be provided to the affected governmental entity. Now, that section doesn't apply. So, similar, not as clearly laid out as it is in Texas. There is no discovery stay here in Florida. Oh my goodness. There's no discovery stay in Florida. There's a lot different in this law than the Texas law that we saw in the Vic case. And it'll be very interesting to see what happens. They're definitely going to try an anti-SLAPP. And they're definitely commenting on a public matter, and at least in the case of HarperCollins, they're doing it in a book. So it'll fall into it for sure. Oh, what is this? Okay. Now, guys, I would love to sit here and read this entire lawsuit to you. And I'm going to in just a moment. I'm out of tea and my throat is killing me, as you can probably hear. So let me go grab another drink. And before I do, I've just realized I gotta get a new whiskey to review for this month. But let's have a little bit of bourbon. So guys, somebody sent me something today that was pure magic. Pure magic. Low T boomer. No, I'm low T. No, I've got plenty more. It's just not with me. Leave me alone. This Corner Creek bourbon is pretty good. I got someone sent me a fantastic string of emails in a lawsuit against Allstate. I don't know if you've seen these things circling around. Oh my God, they're perfect. You want to go through those real quick? It's a nice breather before we transition harder than Brianna Wu into this lawsuit. These are, oh boy. I don't know if you guys, I'm actually gonna have to censor some of them in how I read them because YouTube doesn't like the words. But I do. I love all words. I'm going to see if I can find more information about this, okay? But this is all I've got for now. So this is an exhibit in an ex parte motion to dismiss, all right? This is how this lawsuit has gone. This is some insurance claim where a senior citizen couple, it looks like, is suing Allstate. Because Allstate is not paying, right? Insurance company that doesn't want to pay. Go figure. But these are settlement demand emails. I'm just giggling on the inside because I am definitely reaching out to this attorney. 100%. I will. Man, I want to get this guy on the show. I definitely want this guy on the show. And I don't care if we talk about this case. I have a feeling this guy is a laugh riot. Okay? But here, let's skip down and in pure email form, we're going to go back to the beginning, okay? So it's from Christopher Hook is the attorney. He's an attorney in California. He is a legacy attorney. His grandmother was some famous, well-revered attorney. I believe his father is an attorney, and he is an attorney as well. this is it. This is it. So house in redacted, no mortgage. Tell redacted it is going to be sold to pay my clients, and you guys can rent a place in Lemon Grove. You know how it goes suing insurance companies, I see. So this is Christopher Hook talking to Peter Klee and CCing Mark Feldman. As far as I can figure, Peter Klee is the representative of Allstate. Mark Feldman is another attorney, I believe, representing Allstate as well. Okay? Here we go. Christopher Hook to Peter Klee and Mark Feldman. So that was on November 24th, 2019. This one's on November 23rd, 2019. Wait. Okay, yeah. 8:20 p.m., 12:03. Wait. Hold on. Maybe they are in the proper order. Let me check the dates. Oh, they are. They're in the proper order. Oh, great. So that last one will make more sense as we go. So here's the email chain. It's November 22nd. Here's November 21st. So we don't have the attached, but attention criminal enterprise enablers, please see attached. Attached, he sent a letter to them. Okay. Chris, as I have previously stated, your ever increasing 9-figure demands, the latest being $125 million in a case involving a $200,000 dispute, are counterproductive. Therefore, in-person settlement discussions would not be productive either. And you don't need to come to San Diego. The tone and content of your attached letter do not merit a further response. Okay? So he attached a letter demanding $125 million. Okay, here we go. Then he says, counsel, what would be an appropriate settlement figure in your estimate? They respond, given that the amount in dispute is about $200,000, a reasonable range in which to discuss settlement would be between 0 and $200,000. Haha, fuck you, crooks. Eat a bowl of dicks. All right. Now we're setting it up. What's next? What's the next chain of emails? Then he sends to them, I understand the position you are in. I'm going to let the long dick of the law fuck Allstate for all of us. That's to Mark Feldman. I think Mark Feldman might be representing someone else in the case against Allstate. I don't know. I'm so curious. Here we go. Hey, Klee, you cum stain. The demand is now $302 million. Pay up, fuck face. So, okay. Remember that Peter Klee is the Allstate attorney. It gets better. Peter, when you are done filleting your copy boy, tell Allstate the demand is now $305 million. Next. Mignogna, Seeley, and Barbie may not be too smart, but at least they have some effing dignity and honor, unlike you two limp dick motherfuckers. Next. Oh, God. Here we've got an email chain again. Oh, this is an early one. Why did they included all these out of order? This one was before even the first ones. What is this one? Okay, here we go. November 20th. Mark, if I don't hear from you, I will start seeking injunctive relief in court for the policy limits. I think Judge Wright will agree. I mean today. So Mark responds, Chris, you're escalating settlement demands and threats, now at $100+ million for a $220,000 dispute, are counterproductive towards resolving the case. So this is, remember how it went to over $125 million? This is $100 million. This is $200 million ago. As your reference to injunctive relief for policy limits apply when the damages to a property equal or exceed those limits. Here, the limits are over $1 million, and plaintiff's own contractors have estimated the damages at less than $400,000. In contrast to your emails, you appear to have left a more reasonable sounding voicemail suggesting that your clients were genuinely interested in settlement. If you have a proposal that realistically reflects the amount in dispute, please let me know. Is it? Fuck off. All I need is that transcript and video to get a motion for summary judgment. What is Wright going to do when he finds out Allstate is using people who are borderline retarded to adjust complex claims? That's what I'm going to do. Demand increases tomorrow. Okay? So, next. Now we go back to the 22nd of November. Anytime now, flag it. Flag it. Anytime now, Mundane Matt. He sent this email. He sent this email to an attorney. Oh my God. Here we go. So here's another one. 301.5 million. I want my client's money, gay boys. Next, 306 million, gay boys. It should be BOIS. Come on, Chris, get with the times. Get with the times. Here we go. Hey, shit for brains. Allstate owes my clients a lot of money. It's due yesterday. Pay up, fucktard, or you will be lucky to work as a notary public in El Cajon. Next, we've got him. Hey, fuckface. Today only the claim is on sale for $303 million. If you're too old, impotent, and stupid to even discuss settlement, maybe it's time to hand off the file to Paul Seeley. Oh, but still my beating heart for Chris. Tell Allstate I'm going to waterboard each one of their trolls that show up for deposition without any mercy whatsoever. Don't make me come down there and beat out of you, you fucking thief. Beat what out of you? Just beat out of you. Hey, Clee, you come saying the demand is now 302 million. Pay up, fuckface. You are going to get fucking tattooed across the face, Clee. These are getting a little violent. When I get my motion for summary judgment on file, all bets are off. I'm going to go batshit crazy on you motherfucking cocksuckers. Oh boy. Then there's this one. Wow, Berkeley must be ashamed to have you as an alumni. Big defender of corporate greed and fucking over the California consumer. Your family must be real proud of you, Peter. This case really puts a bow on it. Writing a book about insurance law, then disregarding it to F over 2 senior citizens. Very impressive. This case will be the end of you and your career. We're working on a documentary about this case, and your role as the leading architect of Allstate's program to double down on bad faith by trying to use fancy egghead lawyers without testicles to try and fuck over the consumer. Showtime is interested. Nope, not anymore. This will be my new calling in life. Taking apart Allstate and your fucking piece of shit firm, which I wipe my ass with all the time up here in LA. I am going to DOE you. That's what DOE is. I don't even know. I'm going to DOE you in on Monday, Pete, just like your Ritter book says, for conspiracy to commit bad faith. Hopefully the FBI shuts your little bullshit firm down once and for all. What is the most pathetic thing is that you can't even pick up the phone and say, sorry, counsel, we don't have any authority. You think you're better than me? That you're too good to even pick up the phone and exchange thoughts with me? Well, karma's a bitch, motherfucker. You're going to learn that in spades. I know where you live, Pete. And then here, he doxed him. So that's what this was. House in blank, no mortgage. Tell blank it is going to be sold to pay my clients and you guys can rent a place in Lemon Grove. I'm guessing blank is Pete's wife or husband. I don't judge. You know how it goes suing insurance companies, I see. Oh, baby. Chris is the most red-pilled dude I've seen in a while. And by red-pilled, I don't mean woke. I mean enraged. Maybe that's the crimson pill. So this exhibit is attached to Peter Clee's declaration, and I believe it's his declaration requesting an ex parte order for the judge to dismiss the case because of the attorney. So we'll see. I am 500% reaching out to Chris. I just want to talk to him. I want to know how his law practice goes. I want to learn from this man. Oh boy. Okay. Give me just a minute, guys. I'm going to go grab another beverage that is not liquor that'll soothe my throat as we go through this Zimmerman document. Sorry to break it up with some spicy emails, but they were way too funny. Oh, last thing. Mithran Emmer says, Woolston, quote, those charged with defamation cannot by their own conduct create their own defense by making the claimant a public figure. Argue the coverage of the case made Zimmerman public, not his actions. You can argue it. It's going to be a tough one. But we'll see. We'll see. Chair Kuhn, be funnier. All right. All right. Oh boy. Oh, you know what? Let's do a quick Vic update on this GoFundMe here. We are at $266,430 for Vic Kicks Back on the GoFundMe. Just so you guys know where that stands. Yes, I have heard that Johnny Young Bosch is voicing Broly in Fighter Z, or the new Broly in Fighter Z, which is in. Oh goodness. Which is of course interesting because it's the Broly that Vic voiced. That's the character. I mean, Vic voiced all the Brolys, but it's the character that it's the specific Broly from the movie that Vic voiced just at the beginning of the year when all this started. So he has been. It has been taken over now by Johnny Young Bosch, who I believe is a friend of Vic. Maybe I shouldn't say that. Johnny, I am so sorry. I'm so sorry. Although he doesn't seem to shy away from it. He mentioned speaking to Vic on Twitter and then was promptly accused by the least credible, ugliest person that was around, which is LJ Montello, Geiga Jaw. Her Adam's apple flaring and screaming full-throatedly at Johnny Young Bosch. And I hear a rumor that Geiga Jaw accused Johnny Young Bosch of some sort of sexual misconduct as well, because that's what she does. So anyway, but yeah. And what's interesting is from what I saw, Johnny didn't do, like, he didn't say much about it other than, hey, I talked to Vic about it. You know, he wishes he could do the voice, but he understands in the circumstances. And I have big shoes to fill. He's a great voice actor. Oh my God. How dare he not call him a murder rapist? Like that honestly, that's what it took to go after Johnny Young Bosch, is that he didn't call Vic a murder rapist in his tweet. So there you go. There you go. Imagine if we had Chris on the legal team here calling Lemoyne and company a bunch of gay boys. Oh, God. Does Chris have a Twitter? Am I... Yeah. What is that guy's name? What was his name? Christopher Hook. Oh, my God. Does he have a Twitter? Oh, that's going to be hard to find. Christopher Hook. I don't think I'm going to find him that easy. Wait a minute. Is this him? Nope. I got to find this guy. If anybody can find Chris Hook, the lawyer's Twitter account, please let me know. Let me know. This guy seems like he needs to be... Oh, man. I would love to promote his documentary. I hate insurance companies. And no matter what his conduct ends up ultimately being, insurance companies and their lawyers are absolute garbage heaps to deal with. There's no way around it. There is no way around how absolutely terrible they are to deal with. You know, you pay an insurance company tons of money, and then when you have a claim, the hardest thing to do is to get them to honor that contract. But anyway, let's get into this document. Introduction. Plaintiff George Zimmerman brings his action against Fulton, John... I'm not going to read all the names. I'm going to read the short names. Fulton, John Teal, Eugene, Tracy Martin, Crump, Delarionda, Guy, Corey, FDLE, Florida, in their individual and official capacities where applicable for violations of Zimmerman's constitutional rights under the Florida Constitution, as well as the United States Constitution, as well as the common law, for conspiring to switch and or cover up the identity of defendant Eugene, who is the real phone witness to the events prior to Trayvon Martin's death, by substituting an imposter and fake witness, defendant John Teal, and to assist defendant John Teal in committing perjury in sworn testimony to cause the arrest, prosecution, and sentencing to life in prison of George Zimmerman, as well as causing a federal investigation and prosecution of Zimmerman for civil rights violations. Defendants Crump and HarperCollins. I can't see Crump without saying Crump. Defendants Crump and HarperCollins publishers have defamed Zimmerman in defendants Crump's new book, published by defendant HarperCollins on October 15th, 2019, entitled Open Season Legalized Genocide of Colored People. That's the LGCP. It's a new sister organization to the NAACP. With actual malice, knowing the untruth, or at a minimum, a reckless disregard for the truth. So they are basically conceding that they believe that Zimmerman's a public figure. They believe Zimmerman to be a public figure. They're going with the actual malice standard, and I'm sure they're going to argue that he's not, but it'll be like he might not be. Let's see. Jurisdiction and venue. It's an action for damages in excess of $15,000, exclusive interest costs and attorney's fees. Venue is proper in Polk County, Florida, as plaintiff Zimmerman is a resident of this county and judicial circuit and citizen of Florida. The question is, can they bring everybody else in under jurisdiction? There's no jurisdictional argument for bringing HarperCollins in. They haven't stated why all of these people should be brought in. I don't know if all of these people are in Polk County or not. They might be. They might just be. I don't know. But my first criticism of this complaint is that I would lay out that each of these parties is a resident or whatever. HarperCollins is going to be an interesting one. Now, arguably, HarperCollins does business in Polk County, Florida, but their business is as a publisher. So that's going to be a tough one. Bringing HarperCollins in is going to be tough. Their books are sold in Polk County, but do they specifically market to Polk County? Not really. They deliver stuff to Polk County, to stores, to resell, retailers, but they're a publisher. So I don't know that HarperCollins is necessarily going to be able to be brought in under Polk County's jurisdiction. And he doesn't make the argument here. That'd be my first criticism. George Zimmerman is an individual natural person who at all material times was and is a national citizen and a resident of the state of Florida. Defendant Sabrina Fulton is a former employee of Miami-Dade County, head of the Trayvon Martin Foundation, and currently a politician running as a 2020 Democrat candidate for the Miami-Dade County Commission, District 1 seat. Defendant Fulton is the mother of Trayvon Martin, deceased, ex-wife of defendant Tracy Martin, and a citizen and resident of the state of Florida. Defendant Rachel Gentile is the half-sister of Brittany Diamond Eugene. Defendant, now, of course, they'll be able to bring anyone who's a resident of Florida into this county, no problem. Defendant Rachel Gentile is the half-sister of Brittany Diamond Eugene. Defendant Gentile's mother is Marie Eugene, who is also the biological mother of Brittany Diamond Eugene. After dropping out of Miami Norland Senior High School, defendant Gentile graduated from ACE High School in Miami at age 21. Defendant Gentile is a citizen and resident of the state of Florida and has no known employment. Defendant Brittany Diamond Eugene. Wait a minute. They're sisters? Defendant Gentile's mother is Marie Eugene, who is also the biological mother of Brittany Diamond Eugene. So they're sisters. That was how they did a convincing swap, I guess. Okay. Sorry, that's very weird. Brittany Diamond Eugene is a 2019 graduate of Florida State University, where she was a criminal justice major. She's a resident and citizen of the state of Florida. Defendant Eugene recently worked at Pandora Jewelry Store in Tallahassee. Defendant Eugene is the half-sister of Rachel Gentile. Like Defendant Gentile, Defendant Eugene's biological mother is Marie Eugene, though she was apparently raised by Eliana Eugene, who is believed to be a relative of Marie Eugene. Defendant Tracy Martin is a former employee of Cisco Systems, where he worked as a truck delivery driver. Defendant Tracy Martin has served 5 years in prison in his 20s for being a drug courier. I'm not sure why that's necessarily relevant here. Defendant Tracy Martin is the father of Trayvon Martin, deceased, ex-husband of defendant Fulton, and is a resident and citizen of the state of Florida. Defendant Benjamin Crump is a Tallahassee-based attorney and founder of the law firm Ben Crump Law. Defendant Crump became the attorney for defendants Tracy Martin and Fulton beginning on February 28, 2012, and led efforts to incite the public against Zimmerman and pressure the Sanford police in state of Florida to arrest and prosecute him. Defendant Crump obtained a substantial financial settlement from the Retreat at Twin Lakes Homeowners Association on behalf of four defendants, Tracy Martin and Fulton. As a result of Zimmerman's trial, defendant Crump became a nationally known and self-styled civil rights attorney who represents clients who allege racial bias and police misconduct. On October 15th, 2019, defendant Crump published a book with defendant HarperCollins entitled Open Season, Legalized Genocide of Colored People. He is a resident and citizen of the state of Florida. And if you guys don't know, by the way, if you're not aware of this, Lots of attorneys are trying to do this. Lots of attorneys are trying to do exactly this. Okay? Why do you think they're on Twitter? Why do you think Doucette is on Twitter? Because if you're lucky enough, this is the gross thing, okay? This is not me. This is a Crump, all right? If you're lucky enough, those are air quotes for the audio bot, to have a black kid die on your doorstep and represent his family in a widely publicized case about white people killing black people, even though the white person is very Hispanic George Zimmerman. If you're lucky enough as an attorney for that to fall into your lap, I mean, you make your career immediately. Defendant Crump, you know, he didn't lose the case. That's the best part for him. He didn't lose the case. He won a case against the Homeowners Association. Somehow the Homeowners Association is responsible for the death of Trayvon Martin and all of that. Well, he won the settlement. And he convinced, you know, the feds to investigate Zimmerman and run him through the ringer when Florida decided they wouldn't. That's enough. That's a career. And a very, very lucrative career at that. That's a career that gets grant money from organizations promoting racial equality and stuff like that. That's a career that gets on the radar of Southern Poverty Law Center in the positive way and gets all sorts of accolades and backpats, which translate to dollars and clients in very prominent cases. So, you know, lawyers are people that are motivated by money. Anyway, I want to point that out. This is going for justice, which is why he's written a book on the subject and has expanded his law practice to all over the place. Defendant Bernie de la Rianda is a retired assistant state attorney in the 4th Judicial Circuit in the state of Florida. He was lead prosecutor in state of Florida versus George Zimmerman and a resident and citizen of the state of Florida. Defendant John Guy is a former assistant state attorney who prosecuted George Zimmerman with defendant de la Rianda. Defendant Guy is currently a 4th Judicial Circuit judge and a resident and citizen of the state of Florida. How do you become judge? They elect judges in Florida? Florida judges elected or appointed? Trial judges are chosen in nonpartisan elections. Let's see. Defendant John Guy. Judge John Guy. I wonder how his election went. Let's see. Let's take a look at this article. I don't know if this article will talk about it, but I'm curious. So this is Judge John Guy, 22-year prosecutor, begins circuit judgeship Tuesday. This is back in 2016, January 5th. Let's take a peek at this. John Guy's career hasn't been an accident, but it hasn't exactly gone according to plan either. He didn't go to the University of Florida to study law. That happened after psychology didn't pan out. He didn't become an attorney to be a prosecutor. He wanted to be involved with sports, maybe as an agent. And he didn't become a prosecutor to become a judge. Here he is starting his judicial career Tuesday, taking over Family Law Division C after 22 years in the state attorney's office. It was a place he loved, exciting and fun, but more so, he said, it was meaningful to the families of victims, those he helped bring justice. These people hug you and they will hold on to you. Let's see. Do we have his election results? That's what I care about. making inroads, summer internship, the ones he helped, getting the call, applied to become a judge 4 times in his career. Most recent time was the Fourth Circuit Judicial Nominating Commission had sent his name to the governor for consideration. So after he represents the state against George Zimmerman, he gets nominated for judgeship. Let's see. Phone rang in Naples area code. From conversations with other judges, he knew Governor Rick Scott had a Naples cell phone. Brief conversation informed him he was being appointed to the circuit court to replace Mallory Cooper, who was forced to resign due to age limits. However, guy couldn't share the news just yet, not until the governor's office gave him the okay. So let's see. So he was appointed and then re-elected. This is often how judges end up getting elected. Dang, I wanted to see his election results. I wanted to see if his involvement with the Zimmerman case had anything to do with it. But, yeah, he was appointed by Rick Scott after the Zimmerman case was resolved. Now it was 3 years later. 3 years later. All right, back to it. Defendant Angela Corey is a former Florida state's attorney for the 4th Judicial Circuit Court. She served as special prosecutor to investigate the death of Trayvon Martin and was in charge of the state of Florida versus George Zimmerman's case. Defendant Corey is a resident and citizen of the state of Florida. Just after Zimmerman was acquitted by the jury, Defendant Corey called Zimmerman a murderer in a TV interview. I don't know what she's doing now. Former Florida state's attorney. The Florida Department of Law Enforcement is a defendant whose mission is, quote, to promote public safety and strengthen domestic security by providing services in partnership with local, state, and federal criminal justice agencies to prevent, investigate, and solve crimes while protecting Florida's citizens and visitors. The state of Florida is a defendant. Defendant HarperCollins Publishers is a New York City-based publisher. Now, the state of Florida, it's hard to sue a governmental entity as the entity. Usually you have to sue someone as a representative of the governmental entity. So who knows? That I'm not so sure about. But Defendant HarperCollins Publishers is a New York City-based publisher that describes itself as the second largest consumer book publisher in the world and notes that it has been entertaining, educating, and inspiring generations of readers for 200 years. Owned by News Corp, a global diversified media and information services company whose CEO and owner is Rupert Murdoch and the Murdoch sons. Standing. George Zimmerman is standing to bring this action because he has been directly affected, harmed, and victimized by the unlawful conduct complained herein. His injuries are proximately related to the conduct of defendants, each and every one of them jointly and severally and acting in concert. Facts. On to the facts. Let's see. The facts pled in this complaint, which set forth the injuries suffered by plaintiff, were only recently discovered by plaintiff Zimmerman on or about September 16, 2019, through the publication of the book and film by Hollywood director Joel Gilbert, both entitled The Trayvon Hoax, Unmasking the Witness Fraud, The Divided America. It means that divided America. That's a typo. Goodness gracious. Book and DVD links are here below. thetrayvonhoax.com/book and /film. September 16, 2019 was the earliest possible date that plaintiff Zimmerman could have and did in fact discover the subject, illegal acts, and practices of the defendants which harmed him. They have to overcome the fact that all of this stuff happened a long time ago, right? They've got to get around the statute of limitations. October 15, 2019 was when plaintiff became aware of the book published by defendants Benjamin Crump and HarperCollins and disseminated widely in this circuit, Florida, generally and nationally and internationally. Defendants, each and every one of them as individuals and through their employments and agencies, have worked in concert to deprive Zimmerman of his constitutional and other related legal rights. Defendants, except HarperCollins, each and every one of them instituted, ordered, commanded, conspired, and covered up the illegal substitution of defendant Eugene. a legitimate phone witness to the days, hours, and minutes before the death of Trayvon Martin, with defendant John Teal, an imposter and fake witness who told a made-to-order false storyline to prosecutors in order to cause Zimmerman to be arrested, tried, and convicted for second-degree murder and sentenced to life in prison in a case that had already been investigated and closed by the Sanford, Florida Police Department. And after they had already exonerated Zimmerman, having concluded Zimmerman had acted in self-defense with no probable cause for arrest based on eyewitness testimony, physical evidence, and 911, hashtag never forget, audio recordings. Defendants, except HarperCollins, acting individually and in concert with each other, made a concerted effort to violate Zimmerman's constitutional rights, cause him to be arrested and put on trial for murder, with the goal of imprisoning him for life by covering up their knowledge of the identity of the real girlfriend of Trayvon Martin and legitimate phone witness, defendant Eugene, and their coaching of false testimony and support for the substitution of and lies of an imposter and fake witness, defendant John Teal, that she told to prosecutors. The real question is how they're going to prove this conspiracy out. This is going to be very tough. I'm sure they're hoping for some discovery, which would lead to emails and stuff like that. But I mean, this is a deep conspiracy. I'd be surprised if anything survived. Background as of February 2012. February 2012, Zimmerman was 28 years old, married, and living at the retreat at Twin Lakes Townhome Complex in Sanford, Florida. He was working as a forensic fraud underwriter for Digital Risk and attending Seminole Community College. Zimmerman was studying political science and criminal justice on a path to becoming an attorney. In his spare time, he should continue that path. Why did you stop, Zim? In his spare time, Zimmerman was a social activist and minority advocate. He led a community-wide effort to seek justice for Sherman Ware, a homeless black man who was attacked by the son of a white police officer. Zimmerman was also acting as a mentor in a program for African-American teens whose parents were in prison. After a rash of robberies and home invasions at the retreat at Twin Lakes Townhome community where he lived, Zimmerman joined the Neighborhood Watch program. February 2012, 17-year-old Trayvon Martin was living with defender Fulton in Miami. Trayvon was often getting into fights at Michael Kropp High School and was suspended 3 times. In text messages to a friend, Trayvon lamented only breaking the nose of a student whom he had fought because, quote, he snitched on me, and insisted he would fight the student again because, quote, he ain't bleed enough for me. An expulsion hearing was set for Trayvon after he tried to hit a bus driver. Trayvon's text messages indicated he was dealing handguns to his underage friends and that he was a heavy marijuana user. During this time, Trayvon self-identified as a gangster. Damn, it feels good to be a gangster. And used a Twitter handle that indicated affiliation with the Miami Street Gang. Text messages between Trayvon and his 2 closest friends, Romario Caradici, Mario, and Stefan Bramble, as well as their social media posts, indicate they were engaged in similar dangerous activities. February 2012, 16-year-old defendant Eugene was a sophomore at Miramar High School. In early February 2012, defendant Eugene and Trayvon began a romantic relationship. They spoke on the phone for an average of 5 hours a day. 5 hours a day. Oh, Trey, no, you got sucked into the woman trap. And exchanged about 50 text messages each day. Text messages indicate the relationship was loving, sexual, and often volatile. That's a tagline for a romance novel if I've ever heard. Trey and Eugene's relationship was loving, sexual, often volatile. During her relationship with Trayvon, defendant Eugene simultaneously continued her relationship with her boyfriend of 7 months, Van Jefferson Walter, who was 18 years old. No! Oh, no! Walter was getting cucked. Oh, man. Oh, no. Walter, your girl is on the phone for 5 hours a day with this dude. Oh man, I missed Justice Chat here. Facetious Sage. Here's a bit for your NyQuil fund. I think you just got me sick just breathing towards the screen. Jesus, man. I'm not sick, actually. It's just my voice. Anyway, I've been away for a bit dealing with some real life stuff, and now I come back to you and your Martin death flu. Feel well soon. Hey, thanks, buddy. Welcome back. I feel fine. It's just the voice. Just the voice. Okay. In February 2012, defendant John Teal was an 18-year-old ninth grader at Miami Norland Senior High School. An 18-year-old ninth grader. Defendant John Teal was in the ESE, Exceptional Student Education. Oh, man. It's okay. Okay. I'm sorry. I know Null grew up in Florida, right? But I didn't realize that the Kiwi Farms was in charge of naming Florida educational programs. Defendant John Teal was in Exceptional Student Education Program because she was reading on a 4th grade level and failed 2 years of school. Defendant John Teal often arrived late to school, having led the school in tardies. Well, at least she's achieving something. Oh, my goodness. After Trayvon's his 3rd suspension from school in mid-February 2012, rather than supervise him at home, defendant Fulton kicked him out, according to Trayvon's texts. And Trayvon was sent by defendant Fulton by Greyhound bus to stay with his father, defendant Trayvon Martin, in Sanford, Florida. Get out, get on the bus, and go visit your daddy. Get out. This is how Fresh Prince started, too. I hope you guys remember that. This is exactly the story of Fresh Prince. Too many fights. Get sent by some form of paid transportation to a relative. Trayvon was picked up at the bus station by defendant Trayvon Martin's girlfriend, Brandy Green, taken to her townhome at the retreat at Twin Lakes on February 21st, 2012. Facts pertaining to February 26, 2012. Having slept little the night before due to marijuana use. Wait, I'm pressing X to doubt. And partying with his cousin. Trayvon spent much of the day speaking on the phone and texting with defendant Eugene, who was in Miami. Look. Nobody slept little due to marijuana use. Trayvon was speaking with defendant Eugene both before and after he exited a 7-Eleven store at approximately 6:30 p.m. in the evening of February 26. While driving to Target at around 7:09 p.m., Zimmerman spotted Trayvon standing in the rain between 2 townhomes and making no attempt to get out of the rain. Zimmerman pulled over and called the non-emergency number of the Sanford Police Department to report a suspicious person, as the neighborhood watch group members had been advised to do. Trayvon, while still on the phone with defendant Eugene, then approached and circled Zimmerman's parked car while Zimmerman was still speaking to the dispatcher. Zimmerman described Trayvon to the dispatcher as looking like he was, quote, on drugs or something. Martin was later found to have marijuana in his system above the legal limit to drive in most states. Then, while still on the phone with defendant Eugene, Trayvon departed the area of Zimmerman's car, which Zimmerman also reported to the dispatcher. The dispatcher repeatedly asked Zimmerman which way the person had gone, prompting Zimmerman to get out of his car to try and assist the dispatcher. Zimmerman answered okay in agreement after being asked by the dispatcher not to follow Trayvon. Then, and after failing to find a street address to give the dispatcher where a police officer could meet him, Zimmerman asked the dispatcher to tell the officer to meet him back at his parked car. Zimmerman then walked towards his parked car, and almost there, Trayvon appeared and approached Zimmerman from behind and called out, "What's your problem?" As Zimmerman answered, "I don't have a problem," Trayvon immediately sucker punched Zimmerman in the nose, breaking it, and straddled him as he fell to the ground. That is also a line from a romance novel. Straddled him as he fell to the ground. Trayvon then began slamming Zimmerman's head into the concrete sidewalk and tried to smother Zimmerman as he yelled for help at least 14 times, according to 911 audio recordings. Trayvon was also raining down blows on Zimmerman, MMA style. I'm struggling, y'all, to not bless the rains down in Africa. According to eyewitness Jonathan Good, who, hearing the disturbance, came out of his neighboring townhome and shouted at Trayvon to stop the assault or he would call the police. Trayvon did not stop the assault on Zimmerman. So Good retreated back into his townhome to call police. Zimmerman was disoriented and choking on blood from his broken nose. Fearing he would go unconscious from the continued bashing of his head onto the concrete sidewalk, he reached for his legal firearm and discharged a single shot. No firearms are illegal. There are no illegal guns. Only illegal uses. Discharged a single shot to stop the assault. As he lay gravely injured, Trayvon requested of Zimmerman, "Tell Mama Licia I'm sorry," before passing away. Aw. Licia? Defendant Eugene had been speaking on the phone with Trayvon almost the entire time. 1, while Trayvon was standing out in the rain and spotted Zimmerman's car stopping. 2, while Trayvon was circling Zimmerman's car and observing Zimmerman on the phone. And 3, as Trayvon approached Zimmerman when he was on foot returning to his car. And 4, just before and at least at the beginning of the beating of Zimmerman by Trayvon. Defendant Eugene knew of Trayvon's thoughts, comments, plans, and actions as regards Zimmerman in advance of Trayvon's approaching Zimmerman, both when Zimmerman was in his car and on foot. After her last call with Trayvon disconnected, Defendant Eugene repeatedly called Trayvon and her best friend, Felicia Sinias, over the next 2 hours, even tweeting about her grave concerns while on the phone with Felicia. This behavior indicated Defendant Eugene knew much more than what she would tell Defendant Crump in a recorded phone call and what she wrote in a letter she gave to Defendant Fulton a few weeks later. Facts pertaining to February 27th to March 16th. On information and belief, defendants Tracy Martin, Fulton, and Crump orchestrated a pressure campaign to force Defendant Eugene to make an on-the-record statement that implicated Zimmerman as the aggressor in the altercation with Trayvon in order to have Zimmerman arrested and charged with murder. On information and belief, Defendant Tracy Martin recruited Trayvon's friends to assist in the pressure campaign against Defendant Eugene, including Trayvon's closest friends Mario and Bramble, and Defendant Eugene's best friend Felicia, who is also the sister of Francine Serve, a woman who had worked at Defendant Fulton's home. At the direction of defendants Tracy, Fulton, and Crump, Mario and Bramble bombarded Defendant Eugene with phone calls and text messages at all hours for the first few weeks of March 2012, including while she was at school. Felicia joined in the pressure campaign, sometimes on three-way calls with Mario. Defendant Eugene refused their intense pressure to make an on-the-record statement incriminating Zimmerman, even tweeting about the stressful calls and turning off her phone at times to avoid them. On March 12th, Sanford Police Chief Bill Lee announced the results of their investigation in the February 26th shooting at a public press conference. Lee explained that the Sanford police investigation had included extensive interviews with Zimmerman, eyewitness Jonathan Good, numerous retreat at Twin Lakes residents, reviews of 911 calls, examinations of the physical evidence of Zimmerman's broken nose, head lacerations, and Trayvon's bruised knuckles, and the location of the altercation. Lee declared the investigation concluded. The shooting was an act of self-defense and there were no grounds to arrest Zimmerman. It was not a stand-your-ground case. On March 13th, dissatisfied with the police investigation of the evidence exonerating Zimmerman, on information and belief, Defendant Crump requested the NAACP to write a letter to the DOJ requesting an investigation into the shooting, which resulted in the dispatch of the Community Relations Service of the DOJ to Sanford, Florida. Did you guys know that our federal government has a Community Relations Service that is part of the Department of Justice? That is some I don't trust that at all. I don't trust that at all. My government ever shows up as a community relations service. What community are they relating with? I'm due for an allergy shot, y'all. I'm melting here. All right. Under the guise of a legitimate investigation, the CRS instead helped to organize public protests to demand Zimmerman's arrest, even though there were no grounds for an arrest and no probable cause to arrest or convict Zimmerman in a court of law, all in violation of DOJ ethics and guidelines and the law, as well as Zimmerman's constitutional rights. Why isn't the DOJ included in this? During this time, maybe they didn't participate in the conspiracy, just in the PR campaign. During this time, and despite all evidence to the contrary, in order to defame Zimmerman, incite the public against him, and influence phone witness defendant Eugene, defendant Crump repeatedly disseminated into the media a knowingly false narrative that during the events of February 26, that Trayvon 1 was only buying candy for his little brother, 2 was just trying to get home, when he was 3 stalked by Zimmerman because of his skin color, and then 4 was shot in cold blood by Zimmerman after yelling repeatedly for help. To help convince the public of his false narrative, defendant Crump disseminated a photo of Trayvon to the media of when Trayvon was only about 10 years old and 5 feet tall. That's a tall 10-year-old, y'all. That is a tall 10-year-old. Rather than providing recent photos of the 17-year-old Trayvon who stood over 6 feet tall, defendant Crump repeated his false narrative often, and in doing so successfully coerced the media, politicians, celebrities, and even fair-minded people in demanding the arrest of Zimmerman with no evidence, and even though he'd already been exonerated by the police investigation. Defendant Crump invited Reverend Al Sharpton to assist in this defamation and incitement against efforts against Zimmerman. As at a Florida rally with Sharpton, defendant Crump bragged to the crowd, "We called up to New York City and we called for a man with a track record," referring to Al Sharpton, who he knew was the spokesman for and promoter of the Tawana Brawley race hoax in 87, and incited race-based violence that led to the Crown Heights riots in 91, incited anti-Semitic hatred that fueled the Freddy's Fashion Mart massacre in 1995, left 8 people dead. With Sharpton's help, defendant Crump's defamation and incitement efforts resulted in massive public protests demanding Zimmerman's arrest, death threats against Zimmerman, and was so effective that it even inspired otherwise responsible celebrities like Roseanne Barr. Okay. No, never on earth has anyone referred to Roseanne Barr as otherwise responsible. I'm just saying, you can love Roseanne, you can hate Roseanne, I don't care. But you cannot ever classify Roseanne Barr as otherwise responsible. And Spike Lee to tweet the home address of Zimmerman's parents and invite mob action against Zimmerman's family, who were forced into hiding. Facts pertaining to March 17th and 18th. On both March 17th and 18th, in between coordinated pressure calls from Mario Bramble, as well as Felicia, defendant Tracy Martin telephoned defendant Eugene and spoke with her for about 2 minutes each time. In the evening of March 18th, defendant Eugene was finally coerced under pressure into agreeing to make an on-the-record statement incriminating Zimmerman. Defendant Eugene tweeted about the extreme duress she was under. "Can't believe this is happening to me," crying. She was instructed to meet with defendants Fulton and Crump the next day after school at defendant Fulton's home. Facts pertaining to March 19th. Defendant Fulton texted defendant Eugene throughout the morning. Beginning at 5:13 a.m., Francine Serve, then 22, was the older sister of Felicia Cineas and had worked in the home of defendant Fulton as a caregiver for her brother. That's a little incestuous. On information and belief, defendant Fulton instructed Francine to pick up defendant Eugene after school and deliver her to defendant Fulton's home. According to defendant Fulton's April 2nd, 2012 statement to police after school that day, Francine drove defendant Eugene to defendant Fulton's house, where she dropped defendant Eugene off. Defendant Fulton explained to police that defendant Eugene spoke with her at length. Defendant Crump later indicated he also had met with defendant Eugene at this time. And the afternoon meeting with defendant Eugene, defendants Fulton and Crump requested of defendant Eugene that she return later that evening to appear in an on-camera TV interview with ABC's Matt Gutman to make a statement incriminating Zimmerman. Defendant Fulton stated later in her 2013 deposition that defendant Eugene had also delivered a handwritten letter to her that afternoon, signed Diamond Eugene, that described what defendant Eugene had heard over the phone when speaking with Trayvon before his death. Defendant Tracy Martin wrote in his 2017 book, co-authored by himself and defendant Fulton, Rest in Power, that defendant Eugene entered defendant Fulton's house and had given the letter to defendant Fulton, who read it out loud, and the defendant Fulton started crying. Also, according to defendant Fulton's April 2nd, 2012 statement to police, defendant Fulton then drove defendant Eugene back to her house, where defendant Fulton said she spoke with Eugene's mother, whom defendant Fulton told police had requested that defendant Eugene's identity be kept private. That evening, now Eugene is the legit girlfriend, I think, Diamond Eugene. That evening of March 19th, defendant Eugene declined defendant Fulton and Crump's request to return to defendant Fulton's house for an on-camera ABC TV interview. Instead, she allowed for a recorded over-the-phone interview with defendant Crump. In that 20-minute recorded phone interview, defendant Crump openly coached and led defendant Eugene into repeating his false narrative of events he had been pushing in the media for several weeks. In that recorded call, defendant Eugene repeated almost word for word defendant Crump's false narrative that Trayvon was just trying to get home with candy for his little brother when attacked by Zimmerman based on skin color, even though she knew this not to be true. Defendant Eugene also answered many of defendant Crump's questions in the affirmative, even though she knew them not to be true. Defendant Eugene also appeared to make up some lies on her own to implicate Zimmerman that were not led by defendant Crump. Defendant Eugene also falsely claimed that she did not attend Trayvon's funeral because she had to go to the hospital that day, 6 days after Trayvon's death, where according to defendant Eugene, she was diagnosed with shock when her doctor told her she was the last person to speak with Trayvon. In fact, defendant Eugene was with her boyfriend, Van Jefferson Walter, during that time. Walter's still good with this? Walter! No! Well, Van Jefferson, Mr. Walter now. I wonder if this I wonder if they worked out. I wonder if they ended up together after all of this. Facts pertaining to March 20th. Van Jefferson Watler. I keep calling him Walter. Watler. Van Watler. What is this guy's name? Is this him? Who's this? Oh, is this the guy? This is just Van Jefferson, not Van Jefferson Watler. No, that's not him. I want to see this guy. Dang. I figured he'd been like doxxed and all that stuff by now. I didn't want to dox him. I just wanted to see his picture, you know? I just want to know what he looks like. Okay, sorry. Defendant Crump held a press conference and falsely claimed that defendant Tracy Martin had only discovered the existence of Trayvon's girlfriend on the evening of March 18th, when defendant Tracy Martin checked his phone records. Defendant Crump stated that defendant Eugene and Trayvon were dating and that it was puppy love. Though defendant Crump had addressed defendant Eugene in the recorded call by her name Diamond, defendant Crump refused to identify defendant Eugene by name in the press conference because she is a minor child. Defendant Crump played for the press excerpts from his recorded call with Defendant Eugene in which he implicated Zimmerman with Defendant Crump's false media narrative. Defendant Crump declared to the press, "We have all the evidence now," and arrest George Zimmerman for the murder of Trayvon Martin. Defendant Crump concluded by saying he would not turn over Defendant Eugene's interview recording to Sanford police investigators, but instead would give it to the FBI, which was under the jurisdiction of the DOJ that was organizing protests for Zimmerman's arrest at the same time. Facts pertaining to March 21st, 2012. Defendant Crump appeared on the Today Show with defendants Fulton and Tracy Martin. Defendant Crump told Matt Lauer that Trayvon's girlfriend was a 16-year-old teenager. Defendant Crump also appeared on Court TV. When asked how he discovered Trayvon's girlfriend out of the blue after police had already investigated, Defendant Crump inadvertently admitted the existence of the weeks-long coordinated pressure campaign against Defendant Eugene when he stated on air, "This interview happened, Jane, because we pushed her making a statement." March 28th facts. Defendant Eugene did a 49-minute phone interview with ABC's Matt Gutman, of which only about 1 minute was broadcast that evening on ABC News with Diane Sawyer and the next night on Nightline. In the segment's broadcast, Defendant Eugene repeated several knowingly false statements she had made in the recorded March 19th phone call with Defendant Crump that falsely incriminated Zimmerman. Now, this is a boring section, right? They're just laying out the timeline very specifically. Don't worry, only 20 pages to go. Facts pertaining to March 29th to 31st. On information and belief over this time period of March 29th to 31st, Defendant Eugene helped recruit and coach Defendant John Teal, her half-sister, to pretend to be her in a planned upcoming interview with Florida state prosecutors. On information and belief, Defendant Crump was party with Defendant Eugene to the planning of the witness switch and assisted in the preparation of Defendant John Teal to take Defendant Eugene's place. And both Defendants Eugene and Crump suborned perjury to cause Defendant John Teal to incriminate Zimmerman with Defendant Crump's false narrative. These are huge allegations. Criminal, disbarable, all of that stuff. I might want to check out Christopher Hook's Yelp reviews. A familiar name is mentioned. No. Why do you do this to me? Look at this guy. Oh my gosh, no wonder. It's like Martin Shkreli as an attorney. Look at him. Look at this guy. This guy's just born hilarious. Oh my God. Whoa. Here we go. Where's his Yelp review? The names are Sonny D and Herb H. Oh no. Oh no. Dang it. Guys, stop it. This man does Sonny D. This man does not stand by and let insurance companies walk all over his clients. His flexibility and talent and methods for getting results is second only to the legendary Rick Rekieta. Chris Hook is a fighter, a champion of the cheated and extorted, and he doesn't use kitty gloves. In 1999, a woman had swallowed 3.5 pounds of plastic explosive in a pack of black cats. When Allstate wouldn't cover the resulting damages, Chris reassembled the gory bits of the woman and sued her instead. Waiting staff was friendly. Food was perfect. Temperature. Store was clean with a welcoming atmosphere. I recommend the Chicken Kiev. Okay, you chuckleheads. Oh my gosh. I've got to get that guy on to talk. He's hilarious. Waiting on your answer, gay boys. Okay, sorry. On March 31st, Defendant Fulton texted Defendant Eugene at 8:17 a.m., but she did not respond. Instead, Defendant Eugene phoned defendant Crump at 11:18 a.m. They spoke for 3 minutes and 20 seconds. On information and belief in this phone call, defendants Eugene and Crump finalized the plans for defendant John Teal to pretend to be defendant Eugene to further the conspiracy to incriminate Zimmerman and bring about his arrest, trial, and conviction for murder and sentencing to prison for life based on the pre-planned false testimony of defendant John Teal. April 2nd, prosecutors and police arrived at defendant Fulton's home at around 3:20 p.m. Defendants Fulton and Tracy Martin were interviewed. This is when defendant Fulton made the statements to police about her interactions with defendant Eugene on March 19th, including defendant Fulton's statement that defendant Eugene had been dropped off at her house by Francine Serve and that defendant Fulton had driven defendant Eugene back to her home later in the afternoon of March 19th and spoken to her mother. After defendant Fulton's interview with police was over, defendant Fulton directed the prosecutors and police to defendant Eugene's home at 2648 Flamingo Drive in Miramar to pick her up for an interview with prosecutors. Defendant Fulton knew the address from having driven to her home on March 19th, and prosecutors did not. Defendant De La Rionda confirmed this later in a news interview when he stated about Trayvon's girlfriend, "The only means of communication we had with her was Sabrina Fulton." Arriving at defendant Eugene's home in 2648 Flamingo Drive in Miramar, where she lived with her mother, Eliana Eugene, sister Virginia Eugenia, and it's got to be Virginia Eugene, probably not Eugenia, and grandmother Sainvia Eugene. Prosecutors and police were told defendant Eugene was not at home, but rather she was visiting at the home of defendant Fulton's worker, Francine Serve, at Southwest 3958 52nd Avenue, Apartment 2. Prosecutors, police, and defendant Fulton left defendant Eugene's house and arrived at that same address at approximately 6:30 p.m. to pick up defendant Eugene to be interviewed. Defendant Fulton later stated in her 2013 deposition, "I knocked on the door and asked for Diamond." They wrote out axed. They wrote out axed. Oh, God. However, rather than defendant Eugene coming to the door, defendant John Teal appeared and claimed that she was Diamond Eugene. Defendant Eugene could in no way be mistaken for defendant John Teal, who was 2 years older, 5 inches taller, and about 120 pounds heavier than defendant Eugene. She's a person heavier. Defendant Fulton was alarmed and immediately called defendant Eugene, who tweeted at about the same time at 6:27 p.m. Trayvon Martin mom just called me. She thought I was Trayvon's girlfriend, asking me hella questions. Confused. On information and belief, defendant Fulton did not report that defendant John Teal was an imposter or the switch of witnesses to prosecutors or police. On information and belief, defendant Fulton did not blow the whistle nor reveal what she knew. The defendant John Teal was not defendant Eugene. The defendant John Teal was not Trayvon's girlfriend. The defendant John Teal was not the girl she had met with in her home on March 19th, had spoken with 7 times, had texted with some 30 times, had driven back to her home at 2648 Flamingo Drive on March 19th, and not the girl whose mother she had spoken with, who asked for her identity to be kept private. Defendant John Teal was then driven to defendant Fulton's house, where defendant De La Rionda interviewed defendant John Teal in a sworn statement. Prosecutors violated all legal protocols by allowing the victim's mother, defendant Fulton, to sit next to defendant John Teal during the interview. In the interview, defendant John Teal lied repeatedly in order to incriminate Zimmerman. Defendant John Teal falsely claimed to be Trayvon's girlfriend, falsely claimed that her nickname was Diamond, and falsely claimed that she was on the phone with Trayvon in the days leading up to and much of the day and up to the minute of his death. Defendant John Teal made numerous false statements about what she claimed to have heard while speaking with Trayvon, with the goal of incriminating Zimmerman for the purpose of having him falsely arrested, tried, and convicted of murder, sentenced to life in prison. Man, I hope they pulled cell phone records of this. They could find out which chick he was talking to, right? Defendant De La Rianda ignored the repeated false statements by defendant John Teal that he both knew and should have known to be false, including those which contradicted defendant Eugene's phone records he had already obtained, and included defendant John Teal's statement that she was 18, even though defendant De La Rianda knew from defendant Crump's public statements that defendant Eugene was 16 and a minor child. Almost every time defendant John Teal made a statement he knew to be false, defendant De La Rianda asked the question again and again in different ways until defendant John Teal's answer fit his narrative. By the end of the interview, defendant John Teal was emotionally exhausted and feeling guilty from her lying, and told defendant De La Rianda 6 times, almost shouting, "I feel guilty," and "real guilty." When asked why she felt real guilty, defendant John Teal then stated twice, shouting the second time, "I ain't know about it." Defendant De La Rianda ignored defendant John Teal's confession of being a false witness, all the more obvious since he knew defendant John Teal had lied repeatedly in the interview, and rather than arrest defendant John Teal for lying to prosecutors under oath, defendant De La Rianda ended the interview. Facts pertaining to April 12th. I ain't know about it. That's 4th grade level, reading level, y'all. Defendants De La Rianda, Guy, and Corey knowingly co-authored and executed a fraudulent affidavit of probable cause against Zimmerman, based largely on defendant John Teal's interview statements, and despite knowing that defendant John Teal was an imposter and fake witness, and that her statements incriminating Zimmerman were false, prosecutors used John Teal's false interview statements to mischaracterize Zimmerman's actions with the dispatcher to accuse him of profiling. And all of his, look at this, is pissing me off. His commas are outside of his quotes. His periods are outside of his quotes. Larry, Clayman, and used several of defendant John Teal's knowingly false statements of what she claimed to have heard over the phone, even though they were contradicted by all eyewitness and physical evidence. Another fraudulent feature of the affidavit read as follows: Trayvon's mother has reviewed the 911 calls and identified the voice crying for help as Trayvon Martin's voice. In order to further their conspiracy to arrest and prosecute Zimmerman for second-degree murder, defendants De La Rianda, Guy, and Corey accepted the obviously conflicted victim's mother's word as fact and discounted the simple written testament provided to police by dispassionate eyewitness Jonathan Good. Guy getting hit on ground was wearing red, calling out help. Prosecutors also discounted Zimmerman's claim moments after the shooting to police that he had been yelling for help, as well as defendant Tracy Martin's admission to police that the voice heard on 911 calls screaming for help was not his son's, an admission heard by at least 2 Sanford police officers, all in order to falsely arrest and charge Zimmerman. Facts pertaining to February 5th, 2013. February 5th, 2013, defendant Crump submitted a 29-page affidavit to the circuit court that detailed his interactions with witness number 8 to avoid being deposed by Zimmerman's attorneys. Defendant Crump went to extraordinary lengths in this document to falsify, obscure, misdirect, and lie about his pressure campaign against defendant Eugene and his knowledge that 16-year-old Brittany Diamond Eugene and not 18-year-old Rachel John Teal was the actual phone witness and girlfriend of Trayvon Martin, whom he had met and later interviewed over the phone on March 19, 2012, whose mother he had spoken with, whom he told the media on March 19th was a minor child, whom he told Matt Lauer on March 21st she's a 16-year-old teenager. March 21st, sorry, and with whom he spoke to again on the phone on March 31st. On information and belief, defendant Crump also obscured the fact that he knew about the witness switch and had worked with defendant Eugene to suborn perjury, helping to prepare the imposter and fake witness, defendant John Teal, for her interview with prosecutors on April 2nd, 2012, for the purposes of causing the arrest, prosecution, and sentence to life in prison of Zimmerman. This is bad stuff. Very, very questionable behavior. Guys, I'm going to have to leave you with Chair Coon for just another minute. I'll be back. I'll be right back. All right, all right. Back. Chair Coon is moving. Well, what am I supposed to do about that? I'll get the holy water. We will have an exorcism. Oh my goodness. Okay. Back to it. Facts pertaining to March 13th, 2013 and April 24th, 2013. In her two sworn depositions of March 13th and April 24th, 2013, with Zimmerman's defense attorneys, one on each of these two dates, defendant John Teal lied repeatedly about having a relationship with Trayvon, about being on the phone with Trayvon in the days and minutes up to his death, and lied about everything she claimed to have heard over the phone in the hours and minutes prior to Trayvon's death. Defendant John Teal also lied about her identity, falsely claiming her nickname to be Diamond Eugene. She also lied about signing the letter as Diamond Eugene, which was given by defendant Eugene to defendant Fulton. March 14th, 2013, Tracy Martin deposition. On this date, defendant Tracy Martin lied repeatedly in his sworn deposition with Zimmerman's defense attorneys in order to mislead Zimmerman's defense team regarding his interactions on the phone with defendant Eugene on March 17th and March 18th, and his meeting in person with defendant Eugene on March 19th. Defendant Tracy Martin also lied about having no knowledge of the letter defendant Eugene delivered to Sabrina on March 19th, 2012, which he admitted 4 years later in his book was read out loud to him, in order to further the conspiracy of the witness switch from the legitimate phone witness defendant Eugene to the imposter and fake witness defendant John Teal. And no, I refuse to say her name is Chantel. Jean Teal. For the purpose of causing an arrest and prosecution of Zimmerman for murder and causing him to be sentenced to prison for life. Facts pertaining to March 15th, Sabrina Fulton deposition. In defendant Fulton's sworn deposition with Zimmerman's defense attorneys on March 15th, 2013, defendant Fulton lied repeatedly about the circumstances, events, and persons in question to cover up the identity of phone witness defendant Eugene and her knowledge that defendant John Teal was not defendant Eugene. Defendant Fulton lied repeatedly and often to cover up her two meetings in person with defendant Eugene, about her speaking with her defendant Eugene's mother, Aliana Eugene, and regarding her knowledge of the facts and events surrounding her many interactions with defendant Eugene, both in person and on the phone. Defendant Fulton also lied repeatedly about the circumstances of receiving the handwritten letter from defendant Eugene and signed Diamond Eugene, about the content of the letter and lied about why she hid the critical evidence from police until forced to produce it at her deposition just before the trial. On information and belief, defendant Fulton hid this evidence in order to prevent the defense from an opportunity to run handwriting analysis that would have revealed that defendant John Teal did not sign the name Diamond Eugene, and in order to keep the conspiracy against Zimmerman from unraveling. Facts pertaining to April 2012 to July of 2013. Defendants Della Rionda, Guy, and Corey engaged in a 14-month campaign of obstruction to prevent Zimmerman's defense from discovering the substitution of the real phone witness Brittany Diamond Eugene for the imposter and fake witness Rachel John Teal by withholding evidence from Zimmerman's defense team in order to minimize the time they would have to discover what they knew, that defendant John Teal was an imposter and a fake witness. The obstruction campaign by defendants Della Rionda, Guy, and Corey caused Zimmerman's defense team to spend two-thirds of their time in court demanding discovery and sanctions against the prosecution, all in an effort to prevent Zimmerman's defense from discovering that defendant John Teal was an imposter. The obstruction campaign by defendants Della Rionda, Guy, and Corey included refusing to turn over alleged hospital records until being forced to admit they didn't exist. Providing Trayvon's 750-page Celebrite cell phone extraction report to Zimmerman's defense in an unreadable binary file form rather than a printout. And by denying Zimmerman's defense attorneys access to defendant John Teal by falsely claiming that defendant John Teal was only 16, defendant Eugene's age, before finally admitting defendant John Teal was 19, which he was finally allowed to be deposed just weeks before Zimmerman's trial. Some pretty scummy behavior. Pretty scummy behavior. Guys, I have to point out that the entire sympathetic narrative towards Trayvon is wrapped up in what these people did. If this is true, like the entire sympathetic narrative is in this and is suspect. That's how crazy this is. That's how crazy this lawsuit actually is. Right? Like, if true, I don't know how to express. I still don't like neighborhood watch people in general. I'm not a snitch. I don't like snitches. I don't like any of that culture. If something's happening to you, great. If you see someone actively committing a crime, yeah, whatever. But the idea of like walking around and reporting suspicious people and stuff like that, I'm not a big fan. But the entirety of the narrative rests in really, really questionable things. I mean, of course, we've got the doctored 911 call, right? That was released, doctored by a news station. They were called out on it. All of that, you know, they edited it to make it sound worse than it was. But now combining it with a complete fiction of a witness. I mean, this is crazy. Facts pertaining to July 2013. During the trial of Zimmerman, defendant John Teal appeared in court and testified for 2 days. She lied repeatedly on the witness stand by pretending to be Diamond Eugene and lied about all events and circumstances regarding Trayvon, her relationship with Trayvon, and the circumstances leading up to his death by falsely claiming she was a phone witness to them when she was not, in order to incriminate Zimmerman for murder and send him to prison for life as part of a conspiracy with the others named in this action. Defendant John Teal also falsely claimed she had given the letter to defendant Fulton. She had signed the letter given to defendant Fulton as Diamond Eugene, even though she did neither. Defendants Della Rionda, Guy, Corey, and FDLE prepared and planned the arrest, trial, and prosecution of George Zimmerman, all the while obscuring what they knew and or should have known, that defendant John Teal was a fake witness and an imposter, and that she was not the girlfriend of Trayvon named Diamond Eugene, who was on the phone with Trayvon in the days before and day of the shooting. Defendants Della Rionda, Guy, Corey, and FDLE had in their possession for more than 1 year Trayvon's 750-page Celebrite cell phone records extraction report, which obviously contained at least 4 images of defendants Eugene, that she had texted Trayvon that in no way resembled defendant Gentile. There were also 2 photos of defendant Eugene's cousin JJ, Alexis Jacquet, in the phone records that should have been identified. Defendants De La Rianda, Guy, Corey, and FDLE had read and knew of numerous highly sexual and explicit texts between defendant Eugene and Trayvon, and they knew defendant Gentile had changed her original story from when defendant De La Rianda asked defendant Gentile on April 2nd, "Were you his girlfriend?" Defendant Gentile replied, "We were getting there," to no in her later depositions. Defendants De La Rianda, Guy, Corey, and FDLE had also had the address of 2648 Flamingo Drive in Miramar, where defendant Fulton had directed them on April 2nd, 2012, and knew or should have known that defendant Eugene lived there with her mother, Eliana Eugene, and could have and likely did know this was the same name as on the letter given to defendant Fulton signed Diamond Eugene. Defendants De La Rianda, Guy, Corey, and FDLE also had in their possession from April 15th, 2013, before the trial, the letter signed Diamond Eugene that defendant Fulton finally produced and should have run a handwriting analysis on the signature and would have easily determined it was not signed by defendant Gentile, who could barely write. Defendants De La Rianda, Guy, Corey, and FDLE also had the 20-minute phone recording of defendant Crump, defendant Eugene, in their possession for over a year, as did the FBI, and could have and should have easily determined that the voice on the phone with defendant Crump did not resemble the voice inflections, range, content, or language terminology used by defendant Gentile in her interview with prosecutors. Defendants De La Rianda, Guy, Corey, and FDLE also knew defendant Gentile was 18 at the time and was not a 16-year-old teenager, as defendant Crump had identified her publicly. Woo! This is spicy. Defendants De La Rianda, Guy, Corey, and the FDLE also had defendants Eugene's phone records from Simple Mobile from the period February 26, April to April 2nd, 2012, and with minimal research into the phone numbers would have and should have determined that it was impossible that defendant Gentile was defendant Eugene. Defendants De La Rianda, Guy, Corey, and FDLE also had Trayvon's cell phone records for over a year, and identifying and cross-referencing those numbers would have also revealed it was impossible that defendant Gentile was defendant Eugene. Defendants De La Rianda, Guy, Corey, and FDLE also had all of Trayvon's written text messages between Trayvon and defendant Eugene, contradicted again and again defendant Gentile's claim to have been on the phone with Trayvon and her claim to be defendant Eugene. Finally, defendants De La Rianda, Guy, Corey, and FDLE knew that defendant Gentile had emphatically confessed to defendant De La Rianda that she was lying at the end of her first interview on April 2nd, but used her false statements in Zimmerman's arrest warrant anyway. Defendants De La Rianda, Guy, Corey, and FDLE also knew that defendant Crump's story of the sudden discovery of defendant Eugene on March 18th by defendant Tracy Martin in his phone records was contradicted by the phone records in their possession, showing that, in fact, defendant Tracy Martin had called defendant Eugene on both March 17th and March 18th. And they also knew that defendant Crump had told Court TV that defendant Eugene came forward only because of a pressure campaign, according to defendant Crump. Quote, "This interview happened, Jane, because we pushed her making a statement." Defendants De La Rianda, Guy, Corey, and the FDLE knew that defendant Crump's statement to Court TV was incompatible with defendant Crump's other statements. Let me expound on this just a little bit. Prosecutors and cops make statements of probable cause based on lies all the time. Let's get that out there. They make probable cause statements that lead to charges based on lies all the time. A lot of the time, many times, they know it's a lie. But they think that the lie, if they can pretend they don't know, will lead to evidence that they can then prove. Because they legitimately believe the thing they're pushing. But I want to point out that this thing that's going on with Zimmerman is an extreme example of what happens all the time. Okay? Lies and probable cause statements is not salacious. That's just Chinatown. That's just how it goes. Producing false witnesses knowing about the lies pretty explicitly and producing false witnesses that are literally swapped in. That's different. That doesn't happen all the time. So just so you guys know, I want to point that out. Facts pertaining to defamation. Okay, so all of that other stuff is about swapping an imposter witness. That's not going to be slappable. It shouldn't be. They might file a motion to dismiss under the anti-SLAPP thing. Maybe Gentile can file one because she made statements to a government body under the Florida anti-SLAPP law. But generally speaking, that was not protected First Amendment speech that we're talking about. They're not suing for the words specifically. They're suing for the imposter, the swap. That's what they're suing for. Now they're talking about lies. Larry Klayman's talking about lies and knowing lies and all of that stuff. But the reality is they're suing for the swap and what the damage that caused them. That should not be considered under anti-SLAPP. Now, it could be dismissed on other grounds, but that's not the facts if taken as true in the complaint. That's not anti-SLAPP. The defamation, this is probably going to be subject to the anti-SLAPP statute. Now, whether or not they win on obviously a different question. On October 15th, 2019, defendant Crump released a book published by defendant HarperCollins with a reckless, racially charged, inflammatory, and defamatory title, Open Season, Legalized Genocide of Colored People. Given defendant Crump's widely known knowledge of participation in an association with plaintiff Zimmerman in the Trayvon Martin trial, the title of the book is reasonably understood to refer to plaintiff Zimmerman. This creates the false implication that plaintiff Zimmerman participated and participates in the genocide of colored people. I mean, yeah, but that's thin. Very thin. Defendant Crump publicized and personally promoted this book in both Florida and New York, amongst other locations in the nation. That's grounding the claim in Florida. The book itself also contains numerous false, malicious, and defamatory statements regarding plaintiff Zimmerman. In order to encourage sales of the book with a title stating that murder of African Americans is legal, early in the book in Chapter 3, defendant Crump states regarding plaintiff Zimmerman, quote, testimony at the trial revealed that law enforcement ordered Zimmerman not to pursue the teen and to stand down until police arrived. Zimmerman continued to pursue Trayvon. It's a patently false statement of facts that defendant Crump knows are false. Defendant Crump was the attorney for the Martin family and was party to all the case evidence from just 2 days after the incident. Defendant Crump had early and continued access to the 911 calls and all case evidence and facts, having submitted trial briefs and attended the trial. So much so that defendant Crump was the go-to media expert on the Zimmerman trial, both before, during, and for years after the 2013 trial. Defendant HarperCollins had also had access to the 911 calls and all the evidence in the case, their public records, with knowledge of the false facts in the book or insufficient vetting and a reckless disregard for the truth. Published defendant Crump's numerous false, malicious, and defamatory statements regarding plaintiff Zimmerman. HarperCollins' publishing of these statements was done with actual malice in order to sell books and justify its absurd, inflammatory, racially charged book title, Open Season, Legalized Genocide of Colored People. This is a conclusory statement and is not well drafted. Excuse me. That is a legal conclusion that it was done with actual malice. They should state that it was done. I mean, it's the same thing, but they should state done with either knowledge of the falsity or reckless disregard for the truth. Just saying it's without actual malice is conclusory and not a sufficient statement for the lawsuit. That suggested mass murder of African Americans had been legalized and that plaintiff Zimmerman was at the forefront of this genocide. So reckless was defendant HarperCollins' desire to sell books, it even used the racist term colored people to refer to African Americans in its book title. In order to stoke public anger and fears of legalized genocide of colored people, the official book description reads as follows. Open season. Legalized genocide of colored people. Genocide. The intent to destroy in whole or in part a group of people. In open season, award-winning attorney Ben Crump exposes a heinous truth. Whether with a bullet or a lengthy prison sentence, America is killing black people and justifying it legally. While some deaths make headlines, most are personal tragedies suffered within families and communities. Worse, these killings are done one person at a time, so as not to raise alarm. While it is much more difficult to justify killing many people at once in dramatic fashion, the result is the same: genocide. Taking on such high-profile cases as Trayvon Martin, Michael Brown, and a host of others, Crump witnessed the disparities within the American legal system firsthand and learned it is dangerous to be a black man in America, and that the justice system indeed only protects wealthy, white men. In this enlightening and enthralling work, he shows that there is persistent, prevailing, and destructive mindset regarding colored people that is rooted in our history as a slave-owning nation. This biased attitude has given rise to mass incarceration, voter disenfranchisement, unequal educational opportunities, disparate healthcare practices, job and housing discrimination, police brutality, and an unequal justice system. And all mask the silent and ongoing systematic killing of people of color. Open season is more than Crump's incredible mission to preserve justice. It is a call to action for Americans to begin living up to the promise to protect the rights of its citizens equally and without question. Now, I take umbrage with one line. One line in this thing. It says, unequal educational opportunities. Now, they're representing that as a bad thing, but I submit to you that John Teal received something like 4 times the amount of 9th grade as the average student. So while I agree that there are unequal educational opportunities, John Teal received 4 times as much, and that's the inequality. Defendants Crump and HarperCollins were put on notice that the statements contained in Defendants Crump book were defamatory and chose not to retract the false statements contained therein. The statement regarding law enforcement giving orders to Zimmerman is false. Law enforcement did not order Zimmerman to do anything. Non-emergency dispatcher Zimmerman, the non-emergency dispatcher Zimmerman, whom was speaking with, was not law enforcement. Defendant Crump's statement falsely implies Zimmerman disregarded instructions of a police officer, a serious charge, implying that Zimmerman did something in defiance of the police that led to the death of Trayvon Martin. Statement that Zimmerman was ordered by law enforcement not to pursue the teen is totally false, according to a public 911 calls with Defendant Crump is familiar. After the non-emergency dispatcher repeatedly requested help from Zimmerman in determining where the individual who had circled his car had gone, Zimmerman left his car only to assist the dispatcher. As Defendant Crump knows, when the dispatcher asked Zimmerman if he was following him, and Zimmerman said, yeah, the dispatcher stated in response, we don't need you to do that. And Zimmerman said, okay. Defendant Crump also knows that Zimmerman then asked the dispatcher to have an officer meet him at his vehicle. Defendant Crump also knows from court testimony that the location of the altercation was near Zimmerman's car, that as Zimmerman was approaching his vehicle when he was attacked by Trayvon Martin, as all the evidence proved in court where Zimmerman was acquitted in 2013. Based on the court testimony and 911 calls, Defendant Crump knows that no police officer, nor even the non-emergency dispatcher, ordered Zimmerman to stand down until police arrived. The statement defames plaintiff Zimmerman and leads the public to believe that he defied police officers and acted against instructions of law enforcement to pursue Trayvon, when in fact all evidence presented at trial indicated that Zimmerman told the non-emergency dispatcher he was walking back to his car to meet the officer and was then approached and attacked by Trayvon Martin. as the location of the incident near Zimmerman's car indicated. The 911 recording and all testimony and evidence at trial proves defendant Crump's statements about Zimmerman to be knowingly false. And yet another attempt by defendant Crump to defame and incriminate my client for a charge that he was acquitted of in order to further defendant Crump's financial and other interests. Defendant Crump was at plaintiff Zimmerman's trial, so he had firsthand knowledge that these statements were false. Defendant Crump and HarperCollins were put on notice that the statements are false and defamatory and refused to comply with demands to correct them. Facts pertaining to plaintiff Zimmerman's injuries, defendants except HarperCollins, each and every one of them working together in concert, caused Zimmerman to be unjustly arrested, charged, and prosecuted for second-degree murder by the state of Florida, and also caused Zimmerman to be the subject of a 2-year civil rights investigation by the Department of Justice. These caused Zimmerman to suffer great mental anguish, resulting in Zimmerman requiring professional treatment by psychologists for anxiety, depression, insomnia, and weight gain. Zimmerman was formally diagnosed with depression as well as PTSD and PTSS, which he suffers from and remains in treatment for to this day. Oh boy, that sleep schedule is catching up to me. Because of the arrest, charges, prosecution, and federal investigation, Zimmerman lives in constant fear of physical harm due to regular death threats. He should. He should live in that. Not that it's merited. I mean, that's a thing that I believe fully, that he is constantly in fear of his life. Same with Darren Wilson, which often are expressed in rap music. Now, why'd you do that to me, Zim? Ah! He's got me at death threats. I fully believe the guy receives death threats. But then it's expressed in rap music? Come on, man. As well as online social media commentary. In 2015, a man named Matthew Apperson attempted to murder Zimmerman by shooting a bullet at him that missed his head by inches. Apperson was sentenced to 20 years in prison. Imagine going to prison for the cause of killing George Zimmerman. Plaintiff Zimmerman was kicked out of college and had to abandon career plans to become an attorney. Plaintiff Zimmerman has suffered nearly a complete loss of income as he cannot find work because of his infamy and legitimate fears by employers of violence and boycotts on their company because of the arrest, charges, prosecution, and federal investigation. Zimmerman is unable to live a normal life. Zimmerman cannot circulate as a normal person in public. Zimmerman is unable to date. He was kicked off of several dating websites. Plaintiff Zimmerman lives in constant fear of attack. He often receives constant death threats when he appears in public. Plaintiff Zimmerman has suffered severe loss of reputation, goodwill, and past, present, and future loss of income, earning and other financial damage. First cause of action, malicious prosecution. Plaintiff Zimmerman repeats and realleges. I'm not going to read those lines. A criminal prosecution was commenced against Zimmerman, which was instigated by defendants De La Rionda, Guy, Corey, Florida Department of Law Enforcement, and State of Florida, acting in concert as joint tortfeasors, jointly and severally. This criminal prosecution ended in favor of plaintiff Zimmerman. Criminal prosecution was knowingly instituted by the prosecution defendants without probable cause and with malice, as they knowingly put a false witness in order to try to obtain a conviction against plaintiff Zimmerman, which they were still unable to do. As a result of this malicious prosecution action, plaintiff Zimmerman has suffered severe loss of reputation, goodwill, and past, present, and future loss of income, earning, and other financial damage as set forth above and herein. Second cause of action, abusive process. Abusive process. Criminal prosecution was commenced against plaintiff Zimmerman, which was instigated by the prosecution defendants. Criminal prosecution was commenced by the prosecution defendants for an immediate purpose other than for which it was created. Criminal prosecution was commenced in order to create racial controversy to serve political agenda by trying to pin the death of Trayvon Martin on Zimmerman, whom the prosecution defendants depicted as a Caucasian man, despite the fact that plaintiff Zimmerman is Hispanic and half Peruvian, and a minority advocate and a mentor to minority children. As a result of the abusive process, plaintiff Zimmerman has suffered severe loss of reputation, goodwill, and past, present, and future loss of income, earning and other financial damage as set forth above and herein. Third cause of action. Plaintiff Zimmerman repeats and realleges the preceding paragraphs of this complaint as if set forth in full herein. All of the defendants, except HarperCollins, working together in concert, agreed to put on a false witness with a made-to-order false storyline to try and fraudulently create probable cause to arrest plaintiff Zimmerman and to try to fraudulently obtain a conviction against plaintiff Zimmerman. Defendants committed multiple overt acts in furtherance of this conspiracy, as they did, in fact, put on a false witness against plaintiff Zimmerman. As a result of this civil conspiracy, plaintiff Zimmerman has suffered severe loss of reputation, goodwill, and past, present, and future loss of income, earning, and other financial damages set forth above and herein. Fourth cause of action, defamation for Crump and HarperCollins only. Defendant Crump and HarperCollins published numerous false, misleading, slanderous, defamatory statements to severely harm and damage plaintiff Zimmerman in their book, Open Season Legalized Genocide of Colored People. These false, misleading, and defamatory statements were published in the form of a book, ebook, and audiobook with heavy promotion by defendants Crump and HarperCollins in Florida and the USA. Has been disseminated on the internet and republished elsewhere for persons in this circuit and the entire world to see and hear. These false, misleading, and defamatory statements were published with actual malice, as defendant Crump knew or should have known, in the case of defendant HarperCollins as set forth above, that they were false and misleading, and or at a minimum acted with a reckless disregard for the truth. Defendant HarperCollins had reason to know that the statements were false, or at a minimum failed to do sufficient vetting of the book while exhibiting a reckless disregard for the truth. Crump and HarperCollins had been put on notice of the falsity of the statements, but chose not to retract them. Zimmerman has been severely harmed and damaged by these false, misleading, defamatory statements because they subject him to hatred, distrust, ridicule, contempt, and disgrace. Per se defamatory because they accuse him of having committed a felonious crime. As a result, Zimmerman has suffered severe loss of reputation, goodwill, and past, present, and future loss of income. Defamation per se, which they already have right here. Crump and HarperCollins published numerous false, misleading, slanderous, defamatory statements. These false, misleading, defamatory statements are published in the form of, the same thing. This is the exact same wording. Defendants Crump and HarperCollins have been put on notice, severely harmed, per se defamatory. It's the exact same cause of action. Sixth cause of action, no space on sixth and cause. You could tell he was getting tired of typing. Defamation by implication. Crump and Collins published numerous false, misleading, slanderous, defamatory statements to severely harm and damage plaintiff in their book. These false, misleading, and defamatory statements were published in the form of a book, ebook, and audiobook. Actual malice. Same exact thing. It's the same thing, just by implication. Create the false implication that they ignored the orders of law enforcement in order to shoot and murder in cold blood Trayvon Martin. Loss of reputation. Prayer for relief. $100 million. There you go. That is that, guys. Asking for $100 million. We'll see what happens. There's a lot going on here. But I am dying. I was going to do Twitch tonight, but I cannot. I have to go to sleep. I have to get up and teach in the morning, and I am about to pass out. So, that said, let's read chats and wrap up. If you are someone who pieces out during chats, I appreciate you. Thank you for hanging out tonight. And tomorrow, hopefully, we will have a transcript, because that's what I'm looking for in the Vic case. Otherwise, maybe we will have a guest on. I'll be reaching out to Larry Kleiman. If he wants to come on and talk about this, I'll be reaching out to Chris Hook, or whatever his name is. That guy seems like a true gem. Christopher G. Hook. Good God. Whew. But yeah, so we'll see what happens. This Friday there should be a show. Next Friday there will not be a show. Warning you now, on the 13th there will not be a show. So just so you know. But I believe we will have a show on the 14th instead, which may be a Chad Dad chat. I got to just get confirms. All right, guys. I will. Oh yeah. Let's do these justice chats. Hugh says gets called a grifter. Does have any grift meme shirts on your Teespring store like Tokyo Grift? My disappointment is immeasurable. Dread Clown says George is suing for 40 Maddoxes. I'd like to see monetary demands and lawsuits and increments of Maddox's suit. But would it be 20 million increment or 400 million increment system? We don't know. We don't know, buddy. Maybe he's only asking for 1/4 of a Maddox. Mercenary X. Wow, just wow. Are you sleeping? Oh, are you sleeping away? And now I'm in San Diego. And let me tell you, El Cajon and Lemon Grove are not exactly the best places to live. This guy is just bordering on death. On death of her at this point, and he's got balls of steel, as Duke Nukem would say. Mercenary X says, used to live in LA. Screw you, voice recognition. Seriously, I used to do Lyft driving down there. It's about as trashy as LA can get in those two places. Only the hills in the rural areas are decent in any way to live at. A lot of those are the definition of trash. And Some 87 says, Nick, can I send you a question on Twitter? Asking about a business policy question. They made an error on their site and a bunch of people ordered a thing and now they are recalling the item after they have been shipped off without contacting us. Yeah, you can send it to me on Twitter. Go ahead. Because I don't know what that means right now. Okay, here we go. Howling Warwolf says it's sickening that Spike P was never sent to prison for endangering the lives of an elderly couple over something that had nothing to do with them. Armchair Warlord says, who would win, 12 Angry Men or one JMOL boy? Howling Warwolf is referencing Spike Lee doxing Zimmerman's parents, I believe it was. Claude Gamer says, first super chat. Hey, thank you. Want to tell you that I'm going to release a vid hopefully this week. The title, Every Time Ron Doesn't Know, I'll donate 10 cents to the GoFundMe. There you go. Oh, by the way, guys, I've been invited to a convention in Canada at the end of February, and I am not 100% sure if I can go yet. I'm trying to make it happen. I will announce more details if I am able to go well in advance of the convention. I think it would be fun, and I'm trying to make it work. So, if you are at Canada, I hope to be able to see you. I can't tell you where. I don't want to spoil the convention thing before I can announce it. Like, we haven't talked about that yet. So, just know that has happened and I'm working on it. If I'm able to go, I will definitely tell you guys right away. The Fat Man 56 says, what Stand Your Ground, anyone? Stand Your Ground is a pretrial motion in Florida where after an alleged self-defense shooting, you make a motion to dismiss based on stand your ground factors, in which you have the burden to prove several things: that you were acting in self-defense, that you're wait, I don't know. I don't know what you have to prove. I don't know who the burden of proof is on. But long story short, at the motion hearing for self-defense, you basically lay out, prior to much of anything else, a basic outline of self-defense. And if you qualify, your case is dropped automatically. It's very much overhyped. Lots of shootings are not stand your ground, but some justifiable use of deadly force provisions in some states require a duty to retreat. So if you have the ability to run away rather than pull your gun and shoot, you have an obligation to run away. That's what that means. Stand your ground negates that obligation to run away. That's all it is. But it's not something where cops go, well, stand your ground, you can't arrest you. It's not how it works. Stand your ground comes into play only after you're actually charged with a crime. You make it as an affirmative defense in a pretrial motion to get your charge dismissed. So that's how that goes. Next. Adam Davidson says, love the show, Nick. Do you have an opinion on the Elon Musk defamation case where he called someone pedo guy? I'm curious about it. I need to check in to see how it's going because it's a crazy case. But no, I don't have a specific opinion either way yet. Some nobody says, what a fucking hero. I assume he's referencing Christopher Hook. Ben Frail says, gays in Australia are wailing and gnashing their teeth. Rugby Australia settled their suit from illegally sacked Christian player Israel Folau for a reported $8 million. Leftists are stunned. Gawker's Death Rattle says, Jesus, who called the law firm of Kiwi and Farm? Claude Gamer says, for 10-cent GoFundMe vid, want to say something for the vid? I don't recall. Some nobody says, Crump, they beaten these minorities, y'all. Bebe BB says, off topic, Disney gonna Disney. Can't make Baby Yoda crochet patterns and post it on a blog or a pattern site. Disney had them scrubbed clean. Oh, rude. James says, a 4th grade reading level is great for Floridian. She's above the curve. L Knight VA says, please pray or take a drink for me, for I am sharing the same airspace as Moranica and Jamie this weekend at Sengawa. Gross. Some nobody says, should have also noticed the tuba sound when she walks. Some nobody says, 3/ you sit in a guy chair. Das gay. Some nobody says, how do you hide how old someone is from a court? They lie about it. They don't take birth certificates on these people. Moist John says, is Obama's last name Martin? We figured it out. Big Red Bear says, West Coast or East Coast Canada? If West, cool. Central Canada. No one important says, just want to say thank you, Nick and chat, for being respectful between Johnny Young Bosch and Vic with all this. It means the world to me, and I'm sure everyone else. In my opinion, Johnny Young Bosch is a great guy and a great voice actor. He didn't do anything wrong. He just accepted a role. Nova Zero says, wait, they caused weight gain? Confirmed false accusers are trying to kill people through obesity and, social shunning and mental disorientation. But the fatness is just too far. And tell daddy how big you are. Says, what's going on with your intern, bro? My intern is no longer present. So the Twitter account has been repossessed. Not really repossessed. It was never out of Rekieta Law's possession or Rekieta Media's possession, but now it is operated by an agent of Rekieta Media. So that could be a whole bunch of different people at any given time, but right now it's typically me operating the Rekieta Media Twitter account. So there's no more Intern Chan. Intern Chan is gone, dead, buried and long to be forgotten. So, all right, guys, that's all I got for you tonight. I am going to go to bed because woohoo, I am tired out of my mind. I'm going to try and sleep through this voice thing because I hope tomorrow is going to be a big show. So Gawker's Death Rattle says, Canada at end of February, better layer up, burr. It's no different than Minnesota, really. So, all right, guys. Thanks for hanging out with me tonight. I hope to see you tomorrow. I will not be doing Twitch. And I don't have my thing set up to do the outro music, so I apologize. But I'll try and get it set up for tomorrow. Y'all have a good night. Peace. Peace.